My name is John Carrigan with the law firm of Ross, Earle, Bonan, Ensor, and Carrigan. We are a community association law firm with offices in Stuart and Vero Beach. It is our pleasure to be here today. I want to thank Brenda, Kevin, Sarah for the opportunity to do this. Kevin did mention it's a 4-hour board member certification course. That is 4 hours of content. If you look behind me, I think you can see the numbers on the slides. The last number on the slide is 110, right? So that should be a good progress meter as we get through it today. I want to start out with some high level stuff as to why you're here. So the Florida legislature was very active as it pertains to the implementation of educating and ensuring that board members and officers and directors of associations are properly trained as they go into this. As all of you know, because I'm sure none of you get paychecks from the association, right? You are volunteers. It is very hard to step into a volunteer position without any training and be effective in what you do. It's almost like before the past couple of years, it was on-the-job training. And the purpose of today's course and the DBPR, Division of Condominium, Land, Yacht Sales, and Mobile Homes, put together today's presentation as we go through it. The whole purpose of this, and we'll provide it to you all, I'll give you a link that you guys can download this, is to have this as a pocketbook guidance that you can always look back on as we go through today, but also in addition, as you go out through the year and continuing serving on your board of directors. Now, I say the Florida legislature was active because previously, prior to July 1st of this year, if you were a newly elected board member, you could voluntarily attend a board member certification course, right? Or you could sign the self-certification form. I, as a board member, have read the declaration, the covenants, the bylaws. I agreed to uphold them to the best of my ability. You handed that to the secretary and you were certified under Florida law. We always encourage our clients, if you're a client of our law firm or a client of Vesta, to attend these certification courses because you're going to learn more than reading a 300-page declaration of condominium. But at the end of the day, the legislature found that the most effective way to do it would be to have you actually come in and be trained. So for those of you that have never attended a course before, welcome. We'll do some learning today. As I go through each section, I'll attempt to answer questions that we may have live and in person. And at the end, we'll open the chat box here online. And at that point in time, go ahead and take some questions from there. I've always found that the best part of these is you may not have thought of something, but somebody else may. And when they raise the question, you go, I wonder how that applies to my community. Or, oh, I never thought of that. Right? So today's a real good back and forth to not only speak with myself, but hear how other people are addressing concerns in their community. So I can't look online and see people raising their hands, but here in person, how many people are HOA directors? Can I get a show of hands? Okay. How many are condominium directors? Wonderful. Any cooperatives? Chapter 719? Hearing none? Hey, Chris, how are you? So Florida law is governed by Chapter 718, condominiums, Chapter 719, cooperatives, Chapter 720, HOAs. And sometimes we always forget Chapter 617, which is the not-for-profit corporate statute in Florida, which every one of your associations is. Is anybody in a condominium of 3 stories or more? We have our one special guest. So I'm assuming you're
years old and 12 stories high.
I hear you. I bring this up and I'm trying to delineate who is in which position because this is a presentation that covers all of those chapters I spoke about, right? And so certain chapters, certain slides are going to apply to condominiums. Certain slides are going to apply to homeowners associations. Certain slides are going to apply to those condominium clients of 3 stories or more, right? When we talk about the milestone inspection report, the structural integrity reserve study. So I will do my best because the DBPR combined this into one 4-hour course to delineate when we're looking at a slide who I'm talking to. So if there's any questions or concerns, at least in the room, raise your hand and say, does this apply to me? I'm an HOA. Is that fair? Okay. So when we talk about what the statutory changes are as far as new board member education, there's been a lot of confusion about what am I required to go ahead and do. The good news is you're all here today taking that first step in becoming a certified new director officer, which we will provide you a certification for. Under the condominium statute, the amendment was to 718-112, and I printed it out so I don't mess it up because I know we're being recorded here as it pertains to what the new education requirements are as of July 1st. So every new board member elected after July 1st of 2024 must attend a new board member certification course. As long as you stay till the end of today and eat all the food or take it with you, we will give you a certification. There is no test. So that's the great news. If you're an existing board member that's continuing over, so you were elected prior to July 1st of 2024, you actually have till June 30th of 2025 to complete this course. For those of you that are on boards that have a rollover board members that have continued on that board and you live in a condominium, make sure you let your other board members know. We are a provider. The DBPR is providing guidance. There's other great law firms and great management companies that are providing these types of courses. It does not matter who you get it from, although I'll say I think we're the best, of course, right? But you need to get that course done. And a lot of confusion has developed over existing board members because it's called a new board member education course. They think it's just if you were just recently elected. So make sure you go back and you tell your other directors and officers of that requirement under the condominium statute. In addition, because you've attended today, you're good for this year. But every year thereafter, you're required to attend at least one CLE, continuing education course, from a provider such as us, management companies, about updates in the law. So every year you will attend at least one course and get the latest and greatest update as it pertains to it. That is the state of the current law under Chapter 718 for condominiums. Not to be confused with homeowners associations, which also have a new board member certification course, which totally different standards, right? One, HOAs don't have to be here for 4 hours, but you're going to be, right, for today. And number two is the new board member certification course only applies to directors or officers appointed or elected after July 1st of 2024. So if you were on the HOA board prior to that date and you have continued over and continue in service, you can't take a year off, you go on a cruise or anything like that, you got to continue in your service. You do not have to take the new board member certification course by June 30th of 2025. However, you are going to have a continuing education requirement, which is 4 hours per year for HOAs of 2,500 units or less. And if you're more than that, which we typically think master plan communities, 8 hours per year. So as you can see, there's quite a requirement. The good news is for whether you're a condominium client or an HOA client, being here today is going to satisfy the requirement. And next year, the legislature may change the requirements again, right? So always pay attention to that. I'm sure Vesta sends out bulletins about legislative updates. I know our firm does that for our clients. The goal is to keep you informed of these tweaks in the law and to ensure you properly are certified and meet the educational requirements. When you get done today, you're going to get a certificate in the mail. I'm going to get a list from Vesta, both for those people online and those people present today. We will issue a certificate. We will send that to Vesta, and Vesta will be able to provide that to the attendees at today's meeting. You will take that certificate and you will give it to the secretary of the association or your management company, but it needs to be filed in the official records so that any homeowner that comes along and says, I don't think John Carrigan is certified, we can pull out the educational certificate and confirm that it was completed in a timely manner. Any questions in the room about that? Hearing none. Okay, let's have another flyover of, we talked about the statutes, 718, 719, and 720, and 617. All of you should be aware that you're governed by a set of governing documents. What are those? That's the Declaration of Covenants and Restrictions, or Declaration of Condominium in a condominium, or a master proprietary lease for a cooperative. There's anybody online that's part of a cooperative. That's going to be essentially your Bible for the community. It is the precedential document that controls over all other documents. So when I have a client call up and give me a question, or if you guys want to say, we don't want to incur the legal fees, we think we can look at this ourselves, right? Assuming it's not too complicated. Take a look first at your declaration. What does it restrict? What does it allow? What easement rights does it provide? What maintenance obligations does it outline? That's going to be the number one on the priority list when you talk about governing documents. Under that, you're going to have your articles of incorporation. That is the document filed with the state of Florida that creates your corporate entity under Chapter 617. Generally, that may establish how many directors you have. It may dictate the powers of the board of directors or when you have to go to the membership to ask permission. But it is a formational document that creates the corporate entity. But that's number 2 on the priority list. Number 3 is your bylaws. Your bylaws are the nuts and bolts day-to-day operational document of how you run your community. Meaning, if we have a board meeting, how do we call a board meeting? What's the agenda for the board meeting? What's the notice for the board meeting? The statute may come into play as it pertains to that, and that's why you have good management. That's why you have good legal counsel. But always go ahead and look to your bylaws. How do we call an annual meeting? For HOAs, how do we conduct an election, right? So this is the bylaws that governs the day-to-day operational aspects of the association, how that's done. Under that, sometimes you'll have rules and regulations. Sometimes you'll have ARC restrictions or ARC criteria. Under that, you may have board procedures. But there is this order of priority that is all encapsulated in governing documents that we take a look at as your legal counsel. When you call up and ask us a question, I have pretty much the statutes memorized, but for every single one of my clients, you're a little unique when it comes to the governing documents. And when I am asked a question, the statute says you need to look at the governing documents, and we'll talk about when that applies. That's where I go and start to analyze your legal questions as it pertains to it. So with that being said, that's the education. That's the overview of where you look, right? When you come up with questions about how you operate, what can you restrict? But I think it's important for board members, directors, and officers to get a general sense of what do I look to as I analyze these types of things. Now, let's jump into the presentation. Here, there we go. So as we go through today's presentation, just a general idea, we're going to talk about the DBPR jurisdiction, which is different for HOAs and condos, right? The DBPR is anybody ever been to Tallahassee? Right? I know. Okay. So, if you drive into Tallahassee, the Capitol's on the hill, right? And that's where the DBPR is located. They are the administrative agency that has jurisdiction to the extent authorized by statute, right, to oversee condominiums and cooperatives and to a limited extent HOAs. And as part of the presentation, it's important you understand that what role that they play. So they generally enforce compliance, right, when it comes to the creation of communities. I'm assuming nobody in the room is a developer, right? So we're just going to talk about compliance from after the fact. The DBPR has jurisdiction to investigate on certain items. The DBPR has jurisdiction to issue declaratory statements. The DBPR has jurisdiction over certain arbitrable matters under Chapter 718 and Chapter 719. This will give you an idea for condominium clients only, right? I'm going to try to specify that as to what it is. Procedures related to financial issues, elections, access and maintenance of association records, meetings, conflicts of interest of directors. You hire your brother to be the landscaper for the community. We'll talk about that. There's some slides on that. Removal of a director or officer, that's also known as a recall. And procedural completion of the SIRS and the Structural Integrity Reserve Study and the Milestone Inspection Report, which again is to condos of 3 stories or more. And any written inquiries by a unit owner. A written inquiry is where a unit owner in a condominium or cooperative writes you, sends a certified mail, and says, I have this question, and there's a time frame in which you're required to answer. All of these items for my condominium and cooperative clients are what the DBPR has jurisdiction to investigate. If it's not within one of these buckets, they do not have the authority to investigate it. That does not mean you can't be sued, right? It just means that the jurisdiction of this governmental agency is limited in scope. As to Chapter 720, much, much more limited. I don't want to ruin the surprise in the next slide, but it's only 2 things. So under recalls, right? So where the membership recalls or removes a director, and over election disputes. So if there's some dispute that the association improperly conducted its election, then the DBPR would have jurisdiction over those. So, course at a glance. Right now that we know where the DBPR plays a role as to your community, we're going to talk about meeting notices, fines, suspensions, and I'll add to that enforcement, covenant enforcement, financial transparency as to budgets and reserves, record keeping, official records of the association, and when owners make inspections, financial literacy again, but this one's financial reporting, right? So that's the year end, the summary of the year end. Statutory inspections, so that's my high-rise people, and election processes in notices, and then some final slides on the DBPR. All right, let's talk about meeting notices. Now, before I jump into this, I want everyone to understand that there are several types of meetings in your community. There are board meetings. That's where the board of directors gets together to conduct association business. There are committee meetings. That may be your ARC committee. That may be your fines committee. That may be the building and grounds committee. There may be owner meetings or member meetings. That's where the membership gets together to conduct business. Generally, we think of that in the context of when you're putting forth amendments to pass or it's your annual meeting. All of them have different types of notices required to the membership. So let's start with the most common, the Board of Administration meetings. It is required that you properly notice these meetings anytime a quorum of the board gathers, that's a majority, is present and for the purpose of conducting association business. And I always get the call and say, John, we didn't take a vote, so we didn't conduct business. That's not what the case law provides. If you're getting together to discuss association business, it should be properly noticed, it should be an agenda, and it should be open to the members. This certainly creates hurdles to the flexibility of the board to get together and make decisions. I totally agree. But the legislature has determined that the requirement that it be properly noticed and open to the members is more important than the flexibility of, well, we're just making a decision because we all got together and said that tree needs to be cut down and removed, right? So you need to ensure that you meet these requirements. In a residential condominium of 10 units or more, this has to be done at least quarterly. Most clients meet at least monthly. During the summer sometimes, especially if you live in a snowbird community, sometimes they'll take some summer months off. But I will tell you that if an association is only meeting once or twice a year, there's some concerns that I have about the operation, because how are you making decisions? How are you making decisions about repairing the front entrance to the community, the repair of the fountains? How are you making decisions on a covenant enforcement matter unless you're having these types of meetings? So I strongly encourage my clients to try to schedule at least monthly a board meeting where the board gets together to make decisions on association business. However, you have to do it at least quarterly. And at least 4 times per year, the meeting must include an opportunity for members to ask questions of the board. Adequate notice of meetings is 48 hours posted notice at a conspicuous location on site. I highly encourage clients, because when we talk about what the statute requires, there's the bare minimum, 48 hours notice posted at the mailroom, right, for my condominium clients, or at the entrance gate to the community for HOA clients. We live in a modern world where there's email communication. A lot of clients utilize a member portal website. A lot of clients utilize e-blast to get information out to the community. I highly, highly encourage you, for purposes of transparency, you're not required by statute, but to publish notice of your meetings. When you send the manager out there to go post notice of the meeting, which you're required to do even if you email it, have them also send out an e-blast. Have it posted to the member portal website. You want members to be aware of what's going on. I will tell you that in most instances, unless it's a special assessment or something controversial, none of them are going to show up anyways, right? But you want to ensure you afford them notice and the opportunity to be there if they would have questions or concerns about association business. If applicable, the notice, agenda, and other documents required for the meeting must also be posted on the website. So this is a requirement under the HOA Act of, I think it's HOAs of 100 units or more. You are going to put it on the member portal website. I highly encourage every association to meet that requirement. Board and committee meetings regarding operations. So unit owners have the right to attend and the right to speak as to all designated agenda items. I think there's a slide on this, but why we're talking about agendas. Do not post an agenda that says proof of notice, quorum, new business, old business, adjournment. That provides zero information as to about what is going to be happening at that upcoming meeting. The statute now requires that you have to designate what topics you're going to discuss. We're going to discuss under new business, landscape contract. We're going to discuss retention or firing of our legal counsel, those types of things. Put it as an agenda item. It does not require a whole sentence, but it does require disclosure of the topics that are going to come up. If you're considering a policy, a rule, put it on the agenda and specify so people know to show up if they have an interest in it. In condominium association only, unit owners also have the right to ask questions regarding reports as to the status of construction repair projects, status of revenues and expenditures during the fiscal year, and other issues affecting the condominium. So that's specified by statute. One, if you have an ongoing construction project, I always recommend that in your agenda you have an update as to construction project XYZ. In a condominium and you're doing concrete restoration, if you live in an HOA and you're doing road repavement, so long as that project is going on, my suggestion is to routinely have that as an agenda item. There may be no update, but it is important that you have it on there so that members are aware the project is ongoing and that the board has the opportunity, because it's designated as an agenda item, to provide an update as needed. Unit owners also have the ability to record or videotape meetings. Has anybody here had a unit owner show up with a video camera? Right, or the little recording device? So one, when they come in, always ask them to get your good side, right? But number two is they have the right to do it, but the association has the right to implement reasonable rules and restrictions regarding the videotaping of that meeting. I'll give you an example. Somebody cannot at a meeting pull out their iPhone and turn it on the members and start putting it in people's faces 2 feet from them, okay? You're disrupting the meeting. But they have the right, prior to the meeting, to set up their device, to point it at the board of directors, right? And to hit the record button. And everything at that meeting will be recorded. So interference, movement throughout the meeting, they come in and try to mic you up or set up lights or something like that, that's when you should reach out to legal counsel about implementing reasonable rules and restrictions. But for the most part, you just smile and say, make sure you get my good side, right? And let them go ahead and record the meeting. Now, if 20% of the total voting interest petition the board to address a particular item, that is the ability of members to force an agenda item on the agenda. So there may be certain topics that are important to the community that the board, for some reason, good or bad, has decided not to address at a board meeting. This is a membership's right. If they get 20% of the people to sign on and provide notice to the board, within 60 days, the board has to take up that agenda item at a meeting. I highly suggest that if it is a controversial issue that the board has hesitations about, that you contact legal counsel and have us walk you through. Did they meet the threshold? If they met the threshold, how do you address it? What's the game plan here? What are the legal requirements to do that? We do not want to run or put the association in legal jeopardy to save on a 5-minute phone call to legal counsel to get you through that issue. But understand that is a membership right. If you get that notice in the mail, signed by the members, petitioning for an agenda item, it needs to be recognized under Florida law. Directors voting at a board meeting. Directors present have a duty to vote or abstain to an asserted conflict of interest. So when you show up at a board meeting and you're a director, meeting minutes need to reflect how you voted on every single item. Now, that does not mean with every item you have to do a roll call. What that could mean is there's a motion by John, there is a second by TJ, the motion passed unanimously. That is appropriate in meeting minutes. But if there is a non-unanimous decision on a particular item, you need to call the roll, right? President, yes or no? Vice president, yes or no? And that vote needs to be reflected in the meeting minutes so that every member knows how each director voted on that. Staying silent at a board meeting, which is taken to presumed as agreeing to the action taken, means they are saying yes. So if we call for a vote on a motion and we call all in favor, yay, all opposed, and nobody says anything, the meeting minutes will reflect that director voted in favor. So it is very important that you speak up if you are a nay on a particular item. An abstention. It is permitted, but under limited circumstances. A director who abstains from voting in any action taken on any corporate matter is presumed to have taken no position on the action. But again, the meeting minutes need to reflect that you abstained in the vote. Nobody should be able to go back at meeting minutes and not understand, did the board in totality agree? Right? Generally, proof of notice, adjournment of meeting, unanimously approved, right? And if the board disagree, who voted which way? Did they vote in favor? Did they vote against? Did they abstain? Conflicts of interest. I had mentioned this a little bit earlier. This is the scenario, and it's a little more than I hired my brother to be the landscaper. But as a board member or as an officer of this corporation, you are in a position of power to take money collected from other people and provide it to vendors to provide services to your community. And unfortunately, I'm sure it's no one here, I'm sure it's no one online, but there have been some communities where it was, I'm going to use this to benefit my family, right? And family is defined as a relative within the third degree of consanguinity by blood or marriage. So parent, child, sibling, right? But you know about the family tree. The point being is, if you are going to hire a family member, you need to disclose that to the association. We are not going to hire people without proper disclosure. You can certainly hire your brother to be the landscaper. You can hire your son, who happens to be a contractor, to do repair work for the association, if it is disclosed and if the proper procedure under the statutes is followed. The failure to disclose has two issues. Number one, it's unlawful, right? Investigations from the DBPR, they could levy fines, they could levy sanctions, whatever it may be. But number two, it hurts you politically, right? You put all this effort and capital into getting elected to the board to serve the mission you feel best for your community. And all of that is wiped away because you failed to disclose this. If you really want to hire a relative to serve in some capacity as a vendor for the association, that's completely fine, but you have to do it the right way. So what do you do if you have a conflict of interest, right? The board member can still be there. You can be part of the presentation for the vendor, right? Part of the sales pitch as to why this is the best person to fill this role in serving the community, whether it's landscaping, construction, whatever it may be. When the vote is taken, you must recuse, and the meeting minutes must reflect that you recused, and you must leave the room. So you step out. That does not remove quorum under the statute, right? You still count towards quorum for purposes, but because the meeting minutes reflect that you recused yourself and stepped out of the room, quorum still maintains, but it allows the remaining directors to have an open dialogue about whether this is in the best interest of the community. That last one there, and I think it's on my side over here, voidable. Membership has the right to say, we don't think this is right, and to cancel that contract if there is a conflict of interest at a subsequent membership meeting. I have yet to see a membership get together to be able to do that, but understand that if you receive a petition after a vendor contract is approved that involves a conflict of interest for a director, there is the potential for the membership to challenge that contract. HOA conflicts of interest, a little different, a little bit of the same. You must disclose any activity that reasonably may be construed to be a conflict of interest at least 14 days before voting on an issue of entering into a contract. So a board member in HOA has to disclose 14 days in advance that this exists. And I recommend that it be on the meeting notice that it's a conflict of interest vote. That way, nobody can come along and say they didn't know. They may not have paid attention, right? Oh, I received the notice in the email. I see it right there. I see that it says that. I didn't pay attention to it. I put it in my junk mail, right? but they had the opportunity to come ask questions. They had the opportunity to come object or raise considerations. Other types of meetings. So we talked about other types of committee meetings, membership meetings. These are other types of board meetings. You have your regular assessment meeting or your budget meeting. That's what most of us probably just went through as we adopted our budgets. And that's probably the hardest task as a board member. It's adopting that budget, putting that together. Non-emergency special assessment meetings, right? So that is, we need to repair the lake banks in the community, and it's going to cost us $500,000. We need to levy a special assessment to raise capital to be able to pay the contractor to go in and do that. There's emergency special assessment meetings, especially for my condominium clients if you're on the ocean, right? Hurricane comes through, blows out, the first floor now has sand in it, right? The windows and flooding in the second and third floor, right, happened. There is a special provision under Chapter 718 that allows the board to act outside the normal course in order to secure funds, move reserve funds, or levy special assessments in emergency circumstances. Most importantly, the governor has to declare a state of emergency for your county. So we always start by looking at that. Anybody that lived through, well, I guess you all lived through COVID, right? There was routinely updated extensions of declarations of emergency from the Governor DeSantis at that point in time. And that's what we would look to. If that is in place for your community or your county, then at that point in time, you would have emergency powers under the statute. Talk to your legal counsel before acting always, right? But we will be able to walk you through what that is. Unit or partial use adoption meetings. This is again a board meeting, but this is where we're adopting restrictions that pertain to what you can or cannot do in your unit or what you can or cannot do in your lot in an HOA. So if we're going to implement parking restrictions, if we're going to implement ARC restrictions, what you can or cannot construct on your lot in an HOA, 14-day notice on those types of meetings. And then of course, the last one is closed meetings with counsel regarding threatened or pending litigation, which is a very broad sense. It's been interpreted broadly, but you have the ability on threatened or pending litigation to meet with your legal counsel in private. I highly, highly recommend that you still notice it's a closed board meeting with legal counsel so that nobody can complain there was not proper notice, but you do have that ability to meet and close the meeting and exclude the membership on those types of board meetings. Regular special assessments. So this is very important. When you send out your budget meeting notice, when you send out a special assessment notice, there are certain statutory requirements. You can't just send out a notice and say, we're thinking about adopting assessment. We don't know what it's for what, we don't know how much it's going to be, but we're having a board meeting. Not going to work under the statute. You have to provide 14 days advance written notice to all your members of the board meeting. You have to state how much it is. You have to state what it is for. And you have to state that the board will be voting on that matter at the upcoming board meeting. So there's 3 criteria to those types of matters. I say this, always look at your governing documents too. This applies when your governing documents do not require a membership vote. Mostly in HOAs, but sometimes in condominiums, a special assessment over a certain threshold will require membership approval. So when we talk about adoption of a special assessment, you should be in contact with your legal counsel. Not only can we guide you through, do the members get an input here, but we can help you prepare the notice, or at least review the notice provided by your management company. I've seen some of Vesta's forms. They do an excellent job of outlining these 3 criteria, but really rely on management and the legal counsel if this is up. All right, this is slide 15. This is one, when we send it to you or provide it to you, you're going to want to keep track of. It kind of gives you the ability to look and say, when is notice required? What type of board meeting are we talking about? But it's a good reference point or a cheat sheet. In fact, it's something that when we train in new associates that we go ahead and provide them. All right, so I'm going to just ask in the room, are there any questions or concerns about meetings, board meetings, Any committee meetings, anything of that sort? Hearing none, go ahead.
When you're having a special assessment and the membership is enrolled and the membership votes against that special assessment or repairs or whatever it may be, what do you do as a board member?
Okay, so I'm gonna make sure everyone in line here. The question is, if your governing documents require membership vote on a special assessment, and the members decline to approve the special assessment, what does the board do? The board has to explore alternative options to secure the capital to undertake whatever work it may be. So generally, you can ask the membership to, in a non-high-rise condo, reallocate reserves, right? So we've already have this money set aside for other projects, right? Maybe pool, maybe roads, maybe repainting. Can we use that money to go ahead and take on this immediate need? You're gonna have to pay the piper though when you recalibrate that reserve pool, but at least you can access the cash, but you require membership vote on that. Again, condos 3-story or higher can't do that anymore as of January 1st, but every condos and HOAs typically can. Number 2 would be to explore financing through a bank, which when I first started practicing in 2009, so we were going through the economic recession, we got really good interest rates on that. And so going to get $1 million line of credit was at 2-3%, not a big deal at all. Now it's 7-8%. So when you finance $1 million at 7-8%, it really creates a financial burden on the association. But that would be a discussion that I would suggest you sit down with management, because a lot of times they have connections with good banking that understand cooperatives, condominiums, and HOAs, and legal counsel to go through what the options are in that particular instance. But it's a difficult situation, especially if it's something immediate that needs to be undertaken. Good question. Yes.
Question. We have a situation where there's an association, it's a 3-member board, and one of the president resigned because he sold his unit, and they had a 48-hour notice meeting. It's actually going to be this evening, and one of the 2 board members on the agenda is to appoint a new board member, and that person went into the hospital for heart attack, and they're having open heart surgery. They still want to
Because they were going to be appointed to the board?
No, they were already.
Okay, good.
So, but and it's still, there's only one board member. The other one still wants to appoint tonight. They do it.
So you need to have quorum in order to appoint that additional member. So I don't like calling people from the hospital, but theoretically the solution to the problem is to either delay the vote, right, and continue tonight's meeting until you can establish quorum, or to get them on the speakerphone. Establish quorum, take that motion, get a second, get it passed, and then at that point in time, that additional person would take their seat, and the person that voted them in could hang up the phone, and you guys could go ahead and then have a quorum with the newly.
Hey, John. John, I think your mic might be covered a little.
Yeah. Well, I will. We'll work on that from a technical perspective. So we'll talk after. I'm happy to walk you through that. Any other questions? General questions about board meetings? That's a really good. That's the day-to-day practice of how I live. I get that call in the morning. What do we do? But we'll definitely talk afterwards, and we'll get you through that. So okay, let's move on to fines and suspensions and enforcement. This is what I consider a more difficult side of an association, right? You get on the board with a willingness to improve and better your community, right? When you're on the board, you have a fiduciary obligation to enforce the covenants and restrictions. And what that means is from time to time, you are required to enforce covenants when you talk about parking, when you talk about garbage cans, when you talk about nuisance activity, approval, denial of leases, right? And they move the person in anyways. It's part of your obligation. And it's not the most fun part of being a board member, but it is part of the exercise of your responsibility that you have to do. And our job as legal counsel is to walk you through what tools are available, fines and suspensions being one of those, legal involvement being one of those. But me walk you through before we jump into fines and suspensions, because that's one element of the enforcement. We have somebody that moves into a condominium and they have a large dog, and it's a no pet community. And I have a lovely dog at home. I love dogs, but I'm telling you, in this hypothetical, this is what exists. You're not allowed to have a dog in the community, right? What do? Well, we call up the attorney and I can send a really nasty letter, but that's probably not the best approach. What I recommend is a whittling or spectrum of enforcement that becomes more and more aggressive as we go down there. So the first thing I usually recommend is let's send an educational letter to them, right? Not from the attorney, from management usually, right? Dear Mr. So-and-so, you live in a deed restricted condominium. You may not have known, but we don't allow pets or pets over a certain size or parking in this way, or, you need to get approval for the exterior of your home changes in an HOA, right? Whatever the violation may be. It's requested that you remedy this problem within 14 days, and we thank you for your, participation in resolving this matter. But it's nice. It doesn't threaten anything. And I'm only 15 years into practicing, but I believe that most people engage in violative activity because they just didn't know it was a violation, right? And so what we recommend in those scenarios is that first educational letter. Give them a reasonable time period to comply. And if they fail to comply, then we have to go to the next step. The next step is generally from management, a more forceful enforcement letter. Dear Mr. So-and-so, as we wrote you on this date, you live in a deed restricted community. You were required to do this. You are in violation. If you do not comply, the association will proceed with fines or suspensions, what we're going to talk about, or referral to legal counsel for handling. Now, I'm taking a stronger stance. I'm still giving them the opportunity to fix it, but I've outlined the consequences to them, right, of what's forthcoming. If those two letters don't work, and I will tell you that most of the time, 1 or 2 letters works, right? Then you have to get to fines and suspensions. Then you go to legal counsel and say, we want you to enforce. But these are all avenues which can be explored progressively, simultaneously. It just depends on the severity of the violation. You may call me up and say, hey, we've done the 2 letters. This person's still ignoring us. I will talk through it with you. I will say, well, do we think that a monetary penalty, a fine, will encourage compliance? Do we think that suspending their ability to use the exercise room or access the pool, turning off their key fob by suspending their common area use rights, do we think that will be effective? In most instances, clients say, well, it doesn't cost us anything in legal fees, so yeah, let's do that, right? And we explore that. And that's the tool we go ahead and utilize. Sometimes this is the 4th time this person's in violation for something different, because we're always testing the boundaries. And we say, you know what, fines and suspensions are not a tool that is effective against this individual to get compliance. Let's send them straight to legal. But it's a case-by-case basis. And as you get to the point where we've done the 2 letters, I highly encourage you to consult with your manager, right? Because I'm sure you guys have seen it all before and can provide some good guidance. And that manager is a very good barometer to say, is this something that requires legal involvement? And we need to start eating into our legal budget to go ahead and address it. Now, let's talk about, we've sent the 2 letters, let's talk about fines and enforcement. So under Chapter 718, 718.303, 718.303, that is your fine suspension statute for condominiums. For HOAs, Chapter 720, 305. 720.305. That is your HOA fine or suspension statute. Your governing documents may touch and concern this, so always go ahead and look there. But we always start by looking at the statute because the procedural requirements are statutory driven. So let's assume we've sent the 2 letters. We go through the fine process. In a condominium, it's $100 per violation, up to a maximum of $1,000 in aggregate. It cannot become a lien against their unit. I'm only talking to my condo people. HOA people, cover your ears, right? There's a process by which you have to vote at the board meeting. You have to send notice to the owner giving them the opportunity at least 14 days in advance to appear before a fine committee, right? So the board has levied the fine. Dear Mr. So-and-so, because of your non-compliance, the board has levied a fine of $100 per day up to a maximum of $1,000 for this violation. You have the right to appear before a fine committee on this date, time, and location to appeal this decision, right? And then the fine committee meets and goes through that process. This is the boundaries of the procedural process on that front, right? We talked about the hearing. That committee cannot be the board members that voted. I know the board members would like to say, yes, we uphold our own decision, but you have to find independent people to do it. A fine committee is made up of at least 3 members who are not directors, relatives, or living with the director. So the board member husband or the board member wife can't appoint their spouse, right? And the fine committee meets. The fine committee affords the violative homeowner due process. You give them the floor, let them present their side, right? And then the fine committee does this, thumbs up. Fine committee does this, thumbs down. That's it. You don't get to negotiate the fine. You don't get to reduce the fine. We agree with the board or we decline to enforce the fine in its totality. That's what the independent fine committee does. Once the fine committee makes a decision, you send notice to the owner of the fine committee's decision, and now your fine is in place. That fine notice will provide that that fine is 5 days. It's due within 5 days of the notice. Now, HOA people, right? And this is one of those where the statutes appear similar, but they're not, right? For my HOA clients, if your governing documents allow, your fine can be more than $1,000. Your fine can allow up to $10,000, but it has to be set forth in your governing documents. For most clients in the HOA world, $1,000, the guy's parking his boat in the driveway, right? Or parking his RV in the driveway, and you prohibit that. He'll say, $1,000 is cheaper than storage, right? I'm just going to park in the driveway, pay my $1,000 fine, and they can't do anything about it, right? Well, the answer is we can. But I highly encourage my HOA clients to look to amending their governing documents to allow a fine of up to $5,000 or $10,000. It's still $100 per day, but when you start telling someone, well, we're just going to let this thing roll, and every day that goes by, it's another $100. When you can go after someone for a $5,000 fine or a $10,000 fine, they actually think twice about whether they're going to comply or not. In an HOA, if you get to $1,000, or if your governing documents allow more than that, it can be a lien against the parcel, right? So that's one of those nuances. In an HOA, it can become a lien, but it has to be at least $1,000. I highly encourage clients, especially with a first-time violator, to go through the fine process. Because once you understand the process, and I know Vesta does a great job with their forms to make sure you're meeting all the procedural notice requirements, that it costs you nothing, right? Other than time and effort to go ahead and do it. But it is a great way to go ahead and address it. Suspensions. Let me get through this and I'll write it down because we'll get to it. Suspension of use rights. So sometimes people have been very successful in life and they don't care about the $1,000 fine or the $5,000 fine. But you know what they care about is the ability to play pickleball on Sundays with their friends, okay? Or utilize the pool or the clubhouse, okay? The association can levy a fine. It can also, and it's an and or an or, suspend common area use rights for a reasonable period of time. So I can't do it for 5 years, but could I do it for 3 months? Could I do it for 6 months? Based on the severity of the violation, perhaps. So when we have that phone call after the second letter goes out and we say, well, do we get to do fines or suspensions? This is the conversation I'm having with my clients is, well, tell me about the person that's violating this, right? Are they a person that responds to monetary penalty? Do they utilize the clubhouse? Can we go through the key fob log, right? Identify their key fob and see how often they're using it, or perhaps their kids, right, are using the pool. And you want to get a dad to comply with your covenants, cut off his kids' access to be able to meet their friends at the pool, right? They'll hear all about it. So there's strategies that we think about, but it's really looking at the detailed analysis of each individual person. The association can suspend for a reasonable period of time for violations of the Declaration, Rules, and Regulations. You cannot cut off someone's access through the guardhouse, their ability to enter or exit the community. You cannot shut off someone's cable or internet, okay, for violations of the covenants. It was a very effective way to do it. But the problem is that, one, ingress and egress from the community is now protected by statute. Your utility providers, which I include cable, internet, phone, right? The statute doesn't expressly prohibit it, but a lot of people have access to the outside world through that technology. God forbid you've suspended their cable services, right? They don't have internet and they have a heart attack, can't reach 911. Do you imagine that lawsuit? Okay, so we highly recommend that those are the two areas that we do not touch. One protected by statute, one by practicality. In addition is the suspension. So this is not the person, this is a good citizen. They just don't pay their dues, right? So they're delinquent in payments to the association. If they're more than 90 days delinquent, you can suspend their access to the common facilities. And that's fair. If you're not paying your dues, why do you get to use the clubhouse? Why do you get to use the tennis courts? Suspension in that form is 48 hours notice. It does not require the board vote and then the fine or suspension meeting. If it's a delinquency for a monetary obligation, it's simply a board notice upon 48 hours notice. John Carrigan has not paid his assessments. He's more than 90 days delinquent. We vote in favor of suspending until he becomes current, and then you send notice to the owner about that one. So a great way when we look at delinquencies. Can you write it down and we can hold it to the end? Okay. It's 4 hours. We can make it last 4 hours, but we don't have to. The association may suspend the voting rights. So not the most effective to encourage compliance, right? Because the people that do not follow your rules or do not remain current in your assessments typically don't care about voting in annual meetings, but you have the right to do it. So it's another tool that we always take a look at. All right, this is another slide 20, that breaks down all of the different types of notices. I will say this, and I don't think there's a slide on it. I highly, highly encourage that you treat the fine committee that reviews not only fines, but suspension of common area use rights as a committee with final decision-making authority. That committee should be made up of at least 3 members. You must establish quorum. You must have proof of notice of the meetings. You must keep meeting minutes. So it will have all the formalities of a board meeting. The reason I say that is because I'm the litigator. So I'm in front of a judge after you've levied this fine. And the judge looks at me and says, Mr. Carrigan, where was the notice of this fine committee meeting? Where are the meeting minutes of this fine committee meeting? Boy, does it look good when I can look at the judge in the eye and say, right here, judge, right? All the procedural due process required under the law has been afforded, and here's the documentations to support that.
Just 1 second.
Mhm.
I just want to introduce Joe.
Oh, sure.
This is Joe from J&D Landscaping. He sponsored the lunch here today.
Thank you, Joe.
He's a very busy man, so I didn't want to.
Probably just came from the job, right?
So Joe's just funny. This is Joe, like I said, he does a lot of landscaping in where I am in Brevard County. He's been around for about 20 years. He has all his cards and postcards and all that stuff that you can take with you before you leave. And the kids will also have them too, but he supplied us very nice lunch. We appreciate it very much, Joe. Thank you.
Joe, did you want to say anything?
Glad to be here and thankful to be a part of
All right, cheers. Thank you, Joe. Thank you. All right, we are through fines and suspensions. So I know this gentleman here had a question, and then I'll get to you. So go ahead.
We're a small 16-unit condo. We can't get enough people to be on a planning committee. What do you do?
Well, you can't hold them hostage. I've tried that. It's difficult. If you cannot establish an independent finding committee, you do not have that tool in your tool belt. That's the bottom line. And so what that means is you can still call legal. We can still go through the legal process of a demand for pre-suit mediation or a petition for arbitration. We can walk you through all of that, but you will not have this tool that is a method to secure compliance without incurring legal fees. Okay, so I would tell your members, perhaps at the annual meeting, that if we don't get 3 tributes to be on this independent fine committee, our legal fee bill only goes up if we have to enforce. So we would like 3 volunteers. And frankly, I would assume that I'm hopeful in a 16-unit condominium, you don't have a lot of fines or suspensions that need to be undertaken. I hope most people are good actors in that community. So you can tell the fine committee, you may only have to meet once a year or twice a year when this comes up. Okay. Yes, sir.
HOA arena, where there's a sub-association and a second association being sometimes called.
Okay.
Some of those areas you talked about where you can deny access fall under that master association. Does the new statute now allow the sub-association to access those areas that fall under the master association? To
So,
prevent access, to prevent use of pool?
yep, I hear you. So the question for the people on Zoom is, if you have a master and a sub, and the facilities that you want to suspend are under the master's control, can the sub ask the master to suspend the unit owner's common area use rights? No, you cannot control what the master does or not do. I would encourage the 2 boards to talk though, right? And it really depends, but there's no way for the sub to force the hand of the master. The entity that controls the key fob access, right? That's the entity that gets to make the decision of whether to suspend common area use rights. And a sub-association would not generally have that right. But I'm happy to talk to you about particulars of your community. There could be exceptions, but in a general sense, it is the association with control in the association that's experiencing the violation in the association that has the ability to suspend access for what it can control. So if the sub has control, perhaps, but if it does not, then the master makes its own independent decision. Correct. Okay. All right. I'm going to jump in. Yes. Lori, go ahead.
Now, I get this question asked all the time. When does the $100 a day start?
So the statute does not define that, but I'm going to tell you my best practice. Okay. Especially for HOAs, which have recently, the statutory procedural process now says that if you get to the fine committee meeting and it's been cured, the fine committee has to put a thumbs down, that the fines or continuing fines, the board should vote, and the board should either set the fine for conduct that has existed, that they have proof it existed, or set a date for compliance by which fines will start to accrue. So I'll walk you through that. So guy is parking his boat in the driveway, right? You guys say you can't park boats and RVs in the driveway, right? Board gets to a meeting. Board has 10 pictures, date stamped from the property manager. The boat was in the property on these different days, right? That's a continuing violation. In that instance, I would recommend voting to go ahead and impose the fine for those 10 dates, right? $100 a pop up to the maximum of $1,000. The problem in that scenario where you say, we're going to start levying the fine as of this date is, well, if he removes the boat, I mean, I guess you've gotten temporary compliance, but if he brings it back, you're starting the whole process over. Another scenario in an HOA, ARC is approval required for exterior changes to the unit, okay? Individual comes in and puts in a trellis, which they think is beautiful, but turns out it's really just chain link fence with some weeds on it, okay? Just recently had one like this. In that instance, because it's a permanent improvement that the owner installed, I would encourage the board to set a deadline, right? Now they could say, we're gonna do it for the 10 days that we have pictures of the trellises. But in that instance, the goal is to get the trellis removed And once removed, very unlikely it's going to be put back in. So in that instance, I would recommend that the board go ahead and vote to approve a fine of $100 per day starting 4 days from today, and provide notice to the owner that's the decision of the board, right? So that you give the owner an opportunity to comply. Because remember, in all of this, fines are not a moneymaker, right? I mean, they certainly help. I'm not going to shy away from the extra revenue, but the goal is compliance. And if somebody complies and doesn't repeat the violative activity, I never have a problem with an association saying, you know what, we levied the fine, we imposed the fine, but we're going to waive it. We're not going to ever pursue enforcement of it because you're now a good citizen again, right? But that's really a case-by-case basis, because we all know there's those people that will make you happy today and turn around tomorrow and do what they're going to do. And so, again, it's an individualistic assessment. But the answer to your question, Lori, is the board can prospectively set a date. The board can levy fines for dates where it has evidence the violation exists. But that brings up a really good point. When you're levying fines or suspensions, it is not because, well, as a board member, I remember seeing it, right? We want to have a file, right? With pictures, with written complaints, with evidence to support. And the board should be looking at the board meeting. What evidence do we have, right? Not with the formalities of court, but it's not hearsay, right? It's firsthand observations in a written complaint. It's pictures. I mean, these days, you take a picture with your iPhone or your Android, and it's geolocated. The author is established, right? The date, time is on there. I mean, it has everything I would need to authenticate that in court. So it's very easy, especially for managers when they do their property inspections, to just walk through, snap a picture, and send it to that unit owner's file. Good question. Yeah. All right. We'll get through annual budgets and reserves. Is anybody a treasurer in here? Yes. So, bless you, right? You just went through the war to get through, and especially these days with everything skyrocketing as far as pricing, insurance, vendors, everything. When I hear a client that says, well, we just passed a budget where our assessments went up by 2%, I'm like, did they give you a round of applause? Right? At the annual meeting, literally, they should do that, because in today's economic climate with inflation, it is extremely hard to go and do that. And in a condominium, especially because of the amount of infrastructure you have to maintain. So let's talk in general, because I like to go and do that when it comes to this. I want you to think of your operating account as your checking account, right? It is there for purposes of paying day-to-day operational expenses of the association. We'll get us some slides, but it's your checking account. Your reserve account is your savings account. It is money being put away because we know that future infrastructure items, either capital purchases, right, new pool pump, or deferred maintenance, concrete restoration, roadway repavement for my HOA clients, is going to come due at some point in time. And one option is to just stick our hand out when that moment comes due and says, hey, everyone, we need $5,000. Throw it in, right? But a more prudent approach, in my opinion, and especially in condominiums because it's required by statute, is to go ahead and take a little bit of money every quarter or every month if you're monthly, and put that in your savings account. So when that capital expenditure or deferred maintenance item comes due, you should theoretically have the money there to take care of it. That helps for two reasons. One, from a cash flow perspective, right? You're able to pay and take care of the item immediately. Because even if I levy a special assessment, I have to provide 14 days notice, and I have to send notice to the owners that it's been levied, and then I have to go collect it from the owners. That's 30, 45 days at a minimum. Usually it's longer, right? Versus if I have the money in a reserve account, the roof failed. We need to have them come in and go ahead and do it. Okay, well, how's next week do it, right? Because I have the cash today to do it. So it gives you, it's really, really important to have that money there. For condominiums, and we'll jump into that, you're forced to do it by statute. For HOAs, you're not forced to do it. Most HOAs I work with have voluntary reserves unless the membership voted to require it or the developer initially established it in the governing documents. And we'll talk about all of that. But I want you to understand those two aspects. And for my two treasurers in the room, you know there's a lot more detail that goes into that. From a high level perspective, we're either putting the money in my checking account to be utilized today, or we're putting in a savings account for future use. I also want to give you the context that a budget is a forecast. It is an estimation of what our expenses are going to be over the next year. The goal is, at least under the statute, to have a zero-based budget. That as of December 31st, I write my last check to the landscape vendor, right? Joe, who was here, right? And we have used all the money that we collected that year, right? I mean, that's theoretically in the statute what you're supposed to do. In most instances, treasurers work to build in a little bit of surplus into their budgets because you never know what's going to come up over the year. None of us can look at that crystal ball and nail it to a T. So generally, when you talked about treasurers and operating is, we try to have a little bit of surplus, and then we can carry that over to the next year by reducing assessments or putting that in reserves or what it may be. But it's a forecast. And if something comes up mid-year that was unpredicted or unforeseen, guess what we can do? We can amend the budget. We can increase assessments to the members. Might get you recalled, right? But you got to pay the bills. So understand that we really work, and generally my clients that are on the January 1st to December 31st, work starts in, I'll look you guys, July, August on these types of things. Typically the meeting is in October, maybe into November. Some are still doing it in December. But to get that January 1st assessment in place, set in stone, properly noticed. And now I'm going to walk you through how we go ahead and get there. So the associations must prepare an annual budget which shows the estimated revenues, that's assessments, interest, late fees, fines, if you have a lease for like a cell tower, income into the association. And expenses, which is the administrative expenses, management fees, legal fees, landscaping, right? Whatever that may be for items that come forward on a year-to-year basis. The annual budget is your formal written plan, your forecast for the upcoming year. The goal is to figure out what your expenses are and then ensure you collect enough income to pay for those expenses on your forecast, primarily by virtue of collection of assessments. So when I have the management team and work with the treasurer to go through to create that budget, they're really looking at, okay, here's all of our expenses over the past year. Here's the contractual increases, 3% on cable, right? Whatever it may be. Or feedback from the vendors about what their costs will be next year. And any increase or decrease or whatever it may be. Okay, that equals $1 million at the end of the year. Divide by the number of homes. That's how we create our assessments, right? For HOAs, the budget also needs to include, this is just for HOA clients, an estimated surplus or deficit at the end of the current year. So as you prepare this budget and we get into October, November, and especially December, the HOA should have a pretty good idea if they're going to be operating a surplus or a deficit, and that needs to be indicated on the budget. So what is formally required? One, if you work with Vesta, go to them, right? They do an excellent job of walking clients through this. They have the templates to go ahead and do it, but I'll talk about the particularities. The beginning and end dates of the budget. Most clients are January to December 31st. I have some clients that operate on April 1st. I have one or two clients that operate on a June 30th, or July 1st to June 30th. But that needs to be on there so that people know the period in which the forecast is for. You need to have your income side and your expense side. You need to have, for condominium clients only and cooperatives, fully funded reserves, maybe for HOAs. And we'll talk about reserves in a second and when the maybe for HOAs plays a type. And then assessments per unit type. So for HOAs, for the most part, unless you have different service levels, right? Like you have a villa component of your community and a single family home component of your community, it's a uniform assessment. Here's our total expenses, divide by 100 or however many units you have. In condominiums, there's two options for assessments. One is we take the total amount of expenses and we divide by the number of units. So everybody pays 1/100th or 1/200th or whatever it may be. However, it is permissible, and I have a fair amount of clients that do it by the percentage of ownership of the common elements. And this is typically in condominiums, right, where you have different size units. You have the units in the stack on the side that are 1,200 square feet. We have some in the middle, right, that are 800 square feet. And so what I always say is if you allocate your assessments on a percentage of the ownership interest, go to your declaration, generally Exhibit B, Exhibit A is the legal description, generally Exhibit B is going to define that. And if there's a schedule there that says these units own 0.0175 of the common elements, that's how your assessments are calculated. If there's nothing in your declaration that speaks to that, it is uniform amongst all units. All right, estimated revenues, we talked about this. I'm not aware of any other forms of income, but I guess that's there for purposes of if, for example, you had a lawsuit and you won and the owner paid a giant sum of money for your attorney's fees, right? Because they had to reimburse that because they lost. That could be another form of income that should be allocated on your budget. And estimated expenses. So, of course, the DBPR who prepared this presentation, they want you to know number one expense, their fees. Or I think it's $4 per unit, right? Pay that because the investigators will come after you for that, as I've learned, right? Number two, insurance and fidelity bonding. I know for condominium clients, it's been extremely difficult. For HOAs that have significant building infrastructure, the cost has really, really gone up. And then your general stuff, your admin expenses, management fees, and so forth. Typically, when you're developing a budget, you can take a look at the prior year's budget and see the breakdown. But a diligent treasurer will always go through that and say, hey, if I compare our budget from last year to the GL codes, the general ledger codes, and the different money that went out, are we really thinking of every category, right? Or does a category require subcategories, right? Because we have a different guy for pest control than landscaping and tree trimming, right? So you always want to tweak and try to define and better understand those. Okay, so operating is simply calculation of expenses that tells you what your income is going to be. Now let's talk about the savings account, the reserve account, right? So I talked about two items, capital expenditures and deferred maintenance. These are the statutory definitions on slide 25. But understand a capital expenditure is typically in the form of equipment, right? It's purchased. Maybe a sewer plant, whatever it may be, but it's generally in the form of equipment. And deferred maintenance is generally infrastructure repair. So roadways, roofs, repainting, those types of items. Okay, so HOA people, you can listen, but this is not for you. But I'm going to talk about condominiums in the next couple slides. Every condominium in the state of Florida is required to reserve for these. Roof replacement, building repainting, pavement resurfacing, and any other deferred maintenance or capital expenditure over $10,000, right? So pools, pool resurfacing, pool equipment, sometimes pool furniture if you're a really nice community. Those types of things. Elevators, if you are at a high-rise condominium, right? But you take a look at the money going out, either the year-end financial report or the GL codes, right? You can really determine what are deferred maintenance items, things that do not require replacement every year, right? Or require work more than every year, that are over $10,000. And that should be on your reserve schedule. Again, every condominium must have a reserve schedule, and at least these items must be on there. Everybody knows about Champlain Towers, the tragedy that occurred down in Miami, where there was the collapse of the building. As a result of that, the Florida legislature passed Senate Bill 4D in 2022 or 2023, and it's been tweaked over the next couple years. But it's now coming into effect for any budget adopted after December 31st of 2024. If you are a condominium of 3 stories or more, which I'm sure there's people online, but I know there's at least one here, so I'm going to talk to you on this, right? You are required to have not only, and I'll jump back, those reserves, you're now required to have all of these reserves. And the idea or the intent behind that, and I'm not a legislator, so I'm going to give you my thoughts on it, was that one of the concerns down there was that community could not get the funding to proceed with the work. And so the Florida legislature adopted statutes that said if you're a condominium of 3 stories or more, we are going to force you to save for all of these other categories. So there will never be an excuse, well, we couldn't raise the money to take care of it. And these are all the different items. These are in addition to the normal statutory reserves. All right. HOAs. So condominium clients, turn the ears off. HOAs, I'm going to talk to you now. There are no statutorily required reserves. If you look in 720, it will contemplate that you can impose mandatory reserves, but it is your choice. The statute does not make you go ahead and do it. So when we talk about mandatory reserves, those are reserves that were initially established by the developer. So typically, if you look in your bylaws or your declaration, you'll see thou shall reserve for these categories, right? Or if the membership votes by a majority of the total voting interest, the membership can say, we don't ever want to see a special assessment board. So we are imposing mandatory reserves in our community. Every board from here on out shall put forth a budget that includes reserve categories. If established, the amount reserved in any account is based on the remaining useful life, the estimated replacement cost, and the deferred maintenance expense. And that's your reserve schedule, both in a condominium and HOA. Those are the variables you need to know to determine how much money we have to put away for elevators, roadways, pool resurfacing each year. And that is how much, if you total up the each year contribution for each item, that's how you get the total of how much we have to put in reserves this year. Most HOAs that we deal with have voluntary reserves, meaning the membership has never voted to require them, nor did the developer initially establish them. Voluntary reserves give maximum flexibility to the board because every decision of whether we put money in it this year, if we decide to, are we going to do it at 100% or 75%? If we need to access those funds because we had something come up, it's all within the board's discretion because they're voluntary, right? That being said, if they're voluntary, you have to put certain disclosures on documents as far as financial statements. And because the board today may have good intent, it may fully fund reserves. That does not mean 2 boards from now that people are going to do the same thing. And so what you really run into when you have voluntary reserves is a risk, not necessarily a certainty, but a risk that there will not be enough money there because 1 or 2 boards decided to partially fund reserves or not reserve for a particular year or tap into the savings account for something that was not on the reserve schedule. So that's the risk you run with voluntary reserves. But again, you weigh that against the flexibility and the board makes a business decision as it pertains to it. So let's talk about the different types of reserves. So let's assume that you live in a condominium and you're required to reserve, or let's assume you're in an HOA with mandatory reserves, or let's assume you're in an HOA with voluntary reserves, but you want to do it the statutory way because this board is going to be prudent about the financial position of the association. There's straight line reserves and pooled reserves. Straight line reserves is a bucket formulation. We have the bucket for roof. We have the bucket for elevator. We have the bucket for the pool. We have the bucket for building repainting. And every time someone makes a payment, we sprinkle a little bit in each bucket. But the buckets are segregated. The buckets you can't reach into other buckets without going to the membership and saying, can we do this? Okay. So it's very simplistic. It's very easy for the boards to understand, but it's also very rigid because if the board needs access to money and all the money is not there because an infrastructure item failed early, your pool pump, it's $40,000 because it's a heating component too, requires repair, and you only have $20,000. You now have to go to the membership and ask permission to say, can we pull from a different bucket to come up with the money? Very, very difficult to do. If I'm in an HOA and I'm voluntary, I can just do that. But in this instance, we're pretending that we're staying with the buckets. So from a straight line formula, it's very straightforward, but rigid in that sense until you get a membership vote. The alternative method is the pooled reserve schedule, which means every month we put a little bit for painting, pool resurfacing, roadways, whatever it may be, but it's in a giant pool that exists. And at any point in time, if an infrastructure item fails or a capital expenditure comes due, the board has the ability to reach in the entire pool to grab the money, right? Which is excellent flexibility. You have a hurricane come through, and everybody knows if you've experienced hurricanes around here, especially in the wake of the tornadoes that just came through, right? Those who have cash accessible to get the people in to start taking down the trees that are blocking the roadway, to to get the inspectors up to start looking at the roofs. Those are the people that get the best vendors, right? So having the access to immediate cash through a pooled method is great flexibility for the board of directors. One thing you have to understand though is when you pull from something early because you have access to all this cash, I mean, you got to fix the problem. You have to pay the piper at the end of the day though, because when you go back the next year to recalculate, right, you pulled early for that particular component. Now we have to recalibrate the whole pool. So your contributions to reserve for the next year are going to go up a little bit, right? But I would prefer to have access today to utilize cash to take care of your infrastructure items and come up with a game plan to how we're going to make it and catch back up, rather than to sit there and say, well, it's going to be about 60 days before we can levy the special assessment or take this membership vote to access the money. And we're going to, with, cost of materials going up, right? And the vendor is not going to stick around. They're going to go to the next job. So I highly, highly encourage clients to take a strong look at the pooled schedule. For high-rise condominiums, the DBPR has come out and said that you can utilize the pooled methodology for the SERS reserves. So that's excellent. But it's highly, highly encouraged that whether you're an HOA that has voluntary reserves or whether you're a condominium, is look at the pooled methodology to go ahead and get that implemented. This is kind of a breakdown of, you can see the different categories on my left-hand side, and pooled, it's one pool that we can reach into. Optional reserve examples. So lately we've had, and I think it's wise, some clients add to the reserve schedule, putting away money for emergency repairs post-hurricane. I haven't dove into them how they calculated that, but they like to have a sum of money that's sitting in reserves that can't be touched, except that if there's a hurricane that comes through, they have instantaneous access to cash to go ahead and do that. Rather than build that into the operating budget and carrying over surplus from year to year, they've decided to restrict that in a reserve account.
How can you do that when there's no useful lifespan in a hurricane? How would you calculate?
Creative thinking. I haven't dove into how they do that.
You can't do that for years. You make a big liar out of you. That couldn't be done.
According to the DBPR's presentation, I haven't seen a declaratory statement on this, but this is their presentation. They are considering this as something that can be calculated, so long as it's in excess of $10,000. Okay, you guys have $1 million in reserves. Pretty good interest rates these days. Whether you put that in a high yield savings account, a money market account, a CD, right? But any interest earned has to be put back into the reserve account. The association can establish a policy regarding that. The association, when you collect money from homeowners, they don't write you a reserve check and an operating expense check. They write you one check. You have 30 days to put the money that you collect for the January 1st, 2025 assessment into the reserve account to deposit it. And we should be able to see that on your bank statements or your GL accounting. And the association is permitted to have an inflation adjustment. So if I calculate my reserve schedule today and my elevator was just replaced and it has a 10-year or 15-year lifespan, the number on that is not going to be the number on my reserve schedule, because in 15 years, that cost of that elevator is going to be X number higher. So you are permitted within your reserve schedule to put an inflation adjustment. What you determine that is, talk to the board, talk to the management. Generally, we have clients look at the consumer price index and how that's adjusted. If you use a reserve study specialist, they are excellent at providing what factors the association should look at in a number that you can rely upon for that inflation adjustment. If you do not use an inflation adjustment, you run two risks. Number one is when that item comes due in 15 years, you're not going to have the cash needed to actually replace it. And number two, you run the risk that you're not putting away the appropriate money on a yearly basis to go ahead and ensure that you are fully funded under the statute. Okay, let's talk about the budget meeting. Two different requirements, one for HOA, one for condo. Let's talk about condo first. Once it has been prepared, you have to schedule an annual budget meeting. That's consistent for both. So you're both going to have a budget meeting. The annual budget meeting notice must be mailed, delivered, electronically transmitted no less than 14 days prior to the meeting. That is only for condominiums. Okay. Now, for an HOA, the required notice is 48 hours. However, your governing documents may require more. I have some HOA clients that say it's got to be 14 days, just like the condo statute. So always take a look at your bylaws. I would highly, highly encourage the association to mail out a copy of the budget meeting and a copy of the budget to members ahead of the meeting. It may be an e-blast with a link to the proposed budget and a meeting notice, but keep your members informed. In a condo, you have to send out a copy of the budget and you have to go ahead and mail it to all members. You have to file in the official records an affidavit that the notice was complied with. You have to include a copy of the proposed budget and the reserve schedule. In an HOA, all you have to do is post 48 hours notice, assuming your bylaws don't require additional notice. I highly recommend that everybody just comply with this requirement, right? It creates transparency, it creates membership participation, and in all likelihood, I think I've only been to 1 or 2 meetings in my entire career where a member gave input at a budget meeting and the board budged on something. Generally, the decision's already been made, right? But bring members in, have them encouraged to provide input so the board can be fully informed before making a decision. Okay, now we talked about budgets. Now let's talk about what happens if the association doesn't want to fund reserves. So in a condominium that is 3-story or less than 3 stories, so not you, right? The board has to propose a fully funded budget, right? Based on the reserve schedule with all those different variables we talked about. However, at the time it proposes that budget, it can ask the members, hey, do you want to give us permission to not fully fund this? And if we don't fully fund it, there's a risk you could face a special assessment, but guess what? Your assessments are lower, right? And everybody loves to keep their assessments low, even if it is at the sacrifice of the future. So in a condominium of less than 3 stories, the board can put out an alternative budget and ask the members to either waive reserves or partially fund reserves. That means you are not putting enough money in the savings account based on your schedule. However, you get to keep reserves lower. That's the cost-benefit analysis. When you send out Budget B, you're asking members to partially fund or waive reserves. Waiving means we're collecting zero. We have this nice reserve schedule. It says we're supposed to put away $75,000 this year. We want to put away zero. We're keeping assessments at the bare minimum to continue operation of the community. Rarely happens, right? Generally what we see is boards that try to partially fund reserves, meaning that they want to fund reserves at 75% or 50%. So we're putting some money away. We're being prudent, but also if we fully funded, assessments would double, right? And so we want to get your permission to go ahead and partially fund. If you do that, when you send that, you have to have a membership meeting. The members have to vote. You have to get a totality of the total voting interest to vote in favor of it. So 50% plus 1. And the results are only good for that year. So let me walk you through a scenario. Board proposes a budget A, fully funded reserves. Assessments are $300 per month or $400 per month, whatever you want to call it, right? Board proposes budget B, sends out notice of a special membership meeting to take place consecutively with the board budget meeting, sends out a limited proxy, and says budget B will result in assessments of $250 per month, not $300 or $400, which is the fully funded. Disclosures on that limited proxy says you're partially funding, understand you may have an assessment. Membership either shows up in person at that membership meeting or sends in their proxy, and we show up at the meeting. Board conducts the meeting, conducts the membership meeting. 55% of the membership says we want a lower assessment. Generally, it's higher than that. Generally, it's almost unanimous, right? The board, if you get 50% plus 1 of the total membership, can adopt budget B. If you don't get a quorum of the members to return the limited proxies or appear to vote, or if you don't get the 50% plus 1 threshold, budget A automatically goes into effect. The fully funded budget will automatically go into effect. Everybody knows that lives in an HOA and condo. It is so hard to get people to vote unless you're electronic voting. Apparently that's easy because you can do it on your phone. It's just hard to get people to participate, right? They're up north, or they're busy and they got a family, or they're on a cruise, or whatever it may be. This is the one vote that I generally get really good participation in, because it directly affects how much money's coming out of your pocket, whether it's today or whether it's potentially in the future if a special assessment when we waive reserves. But note, it's 50% plus one, and it's good for that budgetary year. So if we just adopted the budget, membership partially funded or authorized partial funding, in 2025, when I go to do the 2026 budget, I got to take the same vote. For condominiums of 3 stories or more, this was your last year to do it. So I don't know if you did or didn't, but c'est la vie, right? We're fully funding.
Starting October 1st.
Well, there you go. So there you go. Okay. Now, understand that in the event of an emergency, and generally we think of hurricanes, if there's a declaration of emergency, the Condominium Emergency Powers Act comes into play. It allows that if your building is deemed uninhabitable, for the association to pause reserve funding, for the association to access reserves without a membership vote if they're in those different buckets, or for items not on the reserve schedule. What you need to know is when there's a hurricane, you need to be on the cell phone with your management company. You need to be on the cell phone with the attorney, right? We are here to guide you through the process, tell you what or can't do from a legal perspective, and to get people on site to start remediating the damage from the hurricane. Understand that these are the limited exceptions when a hurricane comes through. When that happens, board up, get the supplies ready, and get your attorney and the management company on the speed dial on your cell phone there. Okay, HOA waiving of reserves. So in a HOA with mandatory reserves established by the developer or voted in by the members, you would have to propose a fully funded budget. And if you wanted to propose less, you have to get membership approval. The difference here is you only need to get a majority of those present at a meeting at which a quorum is established. So in a condo, we had to get 50% plus one of everybody. In an HOA, you calculate, did we get a quorum, which is generally 30%, maybe lower, and did we get a majority of those present? If you're putting out a waiver or partial funding of reserves, talk to legal counsel, we can do the math for you. But it's establish a quorum, step one, majority of those. If the majority of those present, right, vote in favor, then you can partially fund mandatory HOA reserves. And of course, you're a voluntary reserve. You can do whatever you want as a board, right? Okay, limited proxy requirements. So this is on the voting of waiver reserves, but this applies generally to limited proxies. You need to have this disclosure here. See where it's in all caps there? It says waiving of reserves in whole or in part. This is the statutory notice that you have to provide on limited proxy mailed to members that says, hey, everyone, if you authorize partial funding or waiver, right, you can do it. That's your right as a member of the association. But there are consequences to that, and that is a special assessment make-up due. And you can see this is a sample one from the DBPR, and you can see what that looks like. It must be in bold, it must be all caps, it must be in a larger font than the rest of it. So jump into Microsoft Word and make sure you meet all those requirements. If we're dealing with voluntary reserves, you have to, if you're in an HOA with voluntary reserves, right? So not implemented by the developer, not required by the governing documents, not approved by the members to have to be done, then you have to include this disclosure in the vote. And you can see all of it right there. Again, all caps, bold, larger font. Okay, that is the end to budgets, the savings account, the operating account, and the checking account. Are there any questions or concerns in the room about that? If you have any questions, go to your treasurer, right? That's what they're there for. And they'll walk you through it. So an attorney talking about math, I understand it, but I generally allow the management and the treasurer. And if you have resources in the community, such as a retired CPA or an active CPA, go use those resources because they can really walk you through it. Questions or concerns before we go to record keeping? Okay. Not good. Okay, so official records of the association. right? One, what are you required to maintain? And two, what are you required to provide access to? The good news is that if you're with Vesta, typically they maintain all your official records. So they should go ahead and be the custodian and ensure and understand what needs to be maintained and be able to provide it to you in an orderly manner. And I know you guys keep a lot of stuff online now, right? And use the technology feature. So it used to be that every association had a banker's box in a storage warehouse with at least 5 rats, right? And somebody would say, I need the financial report from 4 years ago. And somebody would have to put on gloves and go through the box. I mean, it was terrible. The good news is these days, and a lot of these management companies thankfully have pushed us into the 21st century. A lot of it is saved in Dropbox or OneDrive, or I'm sure you guys have a very special system that you utilize that's categorized, that's word searchable, right? So the ability for board members to access information they need has vastly improved. The ability to respond to records requests when homeowners want access has vastly improved. Okay, so we're going to talk about 3 things. What are official records? Unit owner inspections or lot owner inspections, and as of July 1st, 2024, what are association website requirements? So here is a table, tab 44, of what is an official record. If you look down at the bottom left-hand corner, all other written records of the association. It's a catch-all, right? And the HOA statute has very similar language. So I want you to understand that unless excluded, and we'll talk about what those exclusions are, every record of the association should be treated as an official record. That does not mean every communication of every board member, but every record, every contract, every governing document, every roster, every ledger of an association owner's account is treated as an official record of the association that should be orderly kept in order to be able to provide information or documentation to either a board member or a unit owner upon request. This would include, and sometimes let's assume we're doing an elevator project and we prepare an RFP, request for proposal. We send it out to 5 vendors, right? 3 respond and they give their proposals. And we choose the one and we go under contract with the one. All of the stuff that was part of that process is an official record. Okay. So it's just very important that when stuff comes in, it gets put in the right folder electronically, and then it will forever be there in case someone needs access to it. Okay. HOAs and condos are a little bit different as far as when or how long you have to be maintained. So the condominium statute has forever documents. It has 15-year documents, which are only for my high-rise condominiums, 3 stories or more. And the standard is 7 years for basically all other official records of the association, except that there's the 1 year for election voting materials, right? So that would be your limited proxy, that would be the ballots, and contracts and bids. And I think it says contract and bid. Contracts are 7 years. I think what they're talking about is bidding material for projects, as I talked about. For the HOA, the standard is 7 years. Okay. The invention of the internet far predates this, but I'm going to guess that with most associations, once they have moved to the online cloud, you're only required to keep for 7 years. But in most instances, it will go into perpetuity, simply because it takes more effort to go ahead and go through and determine what we can delete, right? Than to just leave it in the cloud and buy more storage. Okay, so all these official records, unit owners have the right to come in and request access for purposes of inspection and for purposes of copying. You cannot say why. They have the statutory right to do it. A good reason, a bad reason, a reason in which they just want to harass and make you do work, which seems to be a lot of the ones that I see. Those are all part of it. But what do they have to do? They have to send in a written request. The association receives the request, and you have 10 business days or working days, I think that's what the statute says, to go ahead and provide access to them. In a condominium only, but an HOA, it's a good idea, you provide a checklist. Here are the 5 items they wanted. And I'm checking as a board member that we provided them, or as a manager that we provided them. In the olden days, right, I have some gray hair, so I can say that, you would bring in the box, we would sit at a large table like this, and they'd say, I want the insurance policy from this date. Okay, here it is, go ahead and take a look at it. You want a copy? Okay, we'll put it on the association's copy, or we'll send it out to a vendor. Practically, and management may have more commentary on this, these days with everything online, you can send people links, right, to certain items that may be accessible. Or if you have a member portal on your website, you can just direct them to go to there. I want the year-end audit for 2023 and 2022. Great, it's available on our member website. Here's the link, right? And you just send them there. So it's actually made it easier to respond to this kind of stuff, especially if you have technology to where the documentation is word searchable, right? We know we were with ACIC for insurance for the past 4 years. Search ACIC. Up in the Dropbox, I can see all the policies right there. Boom, send them to the owner. Took me 5 minutes, right, to go ahead and do. Now, let's walk through a written records request. What do I recommend? Because I have been the attorney for clients that are accused of not responding. One is when a request comes in, it can be email, it could be a letter dropped off, it could be certified mail, right? They are all treated as a written request for access to records. You certify mail it, there's a rebuttable presumption, but don't worry about that. An email creates the ability to prove the association received it as long as the email's correct. Okay, so you can't deny you didn't get the email. When it comes in, the first thing I do is determine, is any of these exempt? Does it request attorney-client privilege communications? Does it request a lease application, which is exempt by statute? Does it request the copy of the social security number of an individual owner, right? Those are exempt from records requests. To the extent it does, the response is, Dear Mr. So-and-so, received your request. These items are exempt. We cannot provide access. We do that in writing, right? And we send it to the owner. Writing could be an email. Writing could be a formal letter. But we create a written record of acknowledgement of receipt and why it's not being provided. To the extent it's not exempt, it's one of those all other official records of the association, we respond, acknowledge receipt, and state the date they will be made available for inspection. Okay, we just set it. If they need another date, they can call me. But when I get into court and the person says, they never gave me access, do you know how much credibility it gives me to go to the judge and say, well, here's their letter, judge, and here 2 days later is our response, and it says we'll give them access right here, and then my client will testify they never showed up for the records inspection. Guess who wins that case? Us. And guess who gets their attorney's fees? Us, right? Versus request comes in, silence, right? Phone call, right? No written record of anything. Becomes very hard for me to prove in court what occurred. So always establish a written record. That does not mean there needs to be 20 communications, but at least that first letter, right? And if they call and say, well, I can't make it, they do another date. All right, I'm gonna send you an email confirming that, right? Creating, again, that written record.
John, is there any restriction? We have one owner who is constantly wanting records. And some of the records that he wanted were financial, monthly financial statements.
Mm-hmm.
And included in that were reports of delinquent owners. Would we do anything with those if they want, once they get those?
Yep, that's a great question. So homeowner account statuses are considered official records of the association, which are accessible and can be copied. But I think the bigger point is that when you give a homeowner access and the ability to copy official records, which you're required to do, can you control what they do with that? The answer is no. Okay, so if they want to start, I had a client that somebody took the time to start a website that was meant to criticize the board, right? So long as it's not defamatory, as long as they're not lying with the intent to damage you, they can do that. I had a client that was starting a YouTube channel. They would go through all the grievances with the board. And I said, we should really give this person a job, right? Because clearly they have good work ethic, but it's just directed towards against you guys. But no, you cannot control. Once you provide them access, you lose control of that item if they request copies. All right. Yep.
So if a homeowner requests, like she said, and they want to see what the delinquency is, the homeowner was told that they could come in and see it, but they couldn't get a copy of it. Is that true?
No, they can get a copy of it. Yep. So I think it's important to realize, though, that if an owner comes in and says, I want these 5 documents, you're only obligated to produce documents that exist. You're not required to create documents that do not exist. So if they say, I had one recently was, I want a timeline of the data of the RFP and the bids that came in and da. That timeline does not exist. We're not going to create it for purposes of responding to records requests. Now, is there an RFP with a date? Is there bids that were received? Is there copies of communications with the vendor? Absolutely. And all of that is provided because it is a document that exists in the real world. But just because someone asks for it does not mean that you have to create new documents that exist. All right? I'm just looking to see, I think we talked about this. Oh, I did point out the third bullet point down. If it exists on your website, the response is it exists on our website. Please go to here, right? And always send them a link. Be courteous. The way I practice, because I litigate a lot of cases, is if a judge looked at this, does it look like I'm being professional and doing the right thing? That's the question. And when you put stuff in writing, be professional, do the right thing, right? And if you have a question about, well, what's the right thing from a legal perspective, pick up the phone and call the attorney. Okay, copies. So my story is I was a second-year associate. This is really before the iPhone had just come out. And somebody came in and I had the box and they brought in a portable scanner that did 1 page at a time. I sat there for 4 hours, none of which was billed to the client, right? And watched this, lady sit there and scan a page and scan a page and scan a page. I had offered, I said, look, I will just go to our copier and we'll just make, nope. We're going to go ahead and do it. But understand that if a homeowner comes in with their smartphone or a camera or a scanner, right, you cannot charge them to take a snapshot of the documents that are there. If they want to use the association's copier, you can charge a reasonable fee for the usage of that, meaning the cost of materials, generally a couple cents per page. Some clients do 25 cents per page. If it's in excess of 50 pages, I generally recommend to clients just say we'll send it out to a third-party vendor. Give them the Post-it notes, tab what you want copied. We'll send it to Kinko's, right? Or I think it's FedEx now. We'll take it down there. We'll get the bill for it. You will pay the bill. I will give you the copies, right? Or use your cell phone. But we're not going to sit here and utilize all the ink in the association's copier and run up at 25 cents a page. So generally, I recommend establish a policy, adopt the policy at that board meeting, right? And that's the policy that's applied to everyone. If it's over 100 pages, we just send it out, right? If it's accessible on the website, we direct them to the website. But we just go through those scenarios. That way, everyone is treated uniformly. Okay, what is not available for inspection? So attorney-client privilege communications, approval of lease, sale, or transfer. So this is generally background checks, right? Or applications to purchase in the community. Guest logs that visit. This is only in the HOA. So you can't go to the security office and say, I want a list of everybody that came through this. Medical records, that would be accommodation requests, like for an emotional support animal. Social security numbers, driver's license numbers, personal identifying information. If you could steal someone's identity with it, right, that should raise a flag. And if it's really a nuanced issue, contact your attorney to see how it should be addressed, right? But we don't want to give out social security numbers, credit card numbers, copies of governmental IDs, or which documentations a lot of associations collect, right? However, it's not subject to an official records request. At the bottom here, compensation in employee records. This does not mean that they can't see the management company's contract. This means that you are not entitled to see the federal FICA withholding on the in-house property manager's payroll, right? It's something the board can see, but as an owner, you're not entitled to that. You're also not entitled to go out and see disciplinary records for employees of the association. So those are things that would be considered exempt from disclosure. But we all know that when you live in close quarters and you have that person that doesn't like the maintenance man, right? This is the exact type of information they request, and that's where we say, we can't accommodate you. So the failure to provide access and the failure to provide timely access can result in causes of action against the association. The fines are $50 per day up to a maximum of $500 per records request that you fail to respond to. $500, not a big deal. However, if they file a lawsuit because you failed to provide the access to the records, they can recover their fees. So now that $500 becomes $5,500 very quickly. And if you didn't provide access, it's kind of hard for me to defend, right? What I'm telling you is give them the records and write them a settlement check. So make sure we just apply to that. Okay, criminal penalties. So is there any first-time board members that just came on the board? No? Okay. So you all know what you existing board members were getting into. Did you know you could be arrested and put in jail? Not to scare you away, right? But there has been such abuse of community associations. Particularly, there's a case in Orlando. There was a case out of, I think, Miami or Southern Brevard, where embezzlement was occurring. Board members were covering up their tracks in controlling the association's official records of what could be accessed to, that naturally the legislature said, look, it is not about just somebody being able to sue the association. If someone is going to engage in such nefarious activity, right, to cover up a crime, right, by virtue of their position of power on the board, there should be criminal penalties attached to that. And so I've yet to have a client go to jail. And if you call me from jail, I'm going to get you a good criminal attorney because I don't do criminal law. But you need to know that there are criminal penalties associated with board conduct that is so extreme and so abusive that any reasonable person would go, yeah, that person should at least spend a night in the cellar, right? So if you intentionally deface or destroy accounting records of the association, and that's what was occurring at these ones where there was embezzlement. If you knowingly, willfully, and repeatedly violate any specified requirement relating to records inspections. So if you intentionally sit back and go, nope, just not sue me, not going to recognize me, right? Depends, but like that's approaching the area where you're now verging into potential criminal liability. And if you willfully and knowingly refuse to release association records with the intent to avoid or escape detection of essentially another crime. So HOAs are not the best place to engage in criminal activity anyways, but note that there was a lot of concern when these statutes first came out. Oh my God, if you fail to respond to a records request, are you going to get arrested, right? I don't think our local prosecutors are interpreting that way, but I think that if there are other crimes, this is one of those add-on crimes that they add to it, right? But you need to be aware is your fiduciary obligation, your capacity as a board member, you can be sued, right? Association has to indemnify you, but now there is criminal liability if you're engaging in this extreme behavior. Of course, nobody online, nobody here would ever engage in that, but you need to be aware of it when you're thinking through these types of processes. In a homeowners association, this is July 1st of 2024, an owner now can make a request for a written accounting. If they do that, give them a copy of their statement. Call a Vesta and say, I need a copy of their statement. That's it. And you just provide it to them. So they made this whole statute. Apparently there were some associations that would not timely respond to owners when they were requesting, how much do I owe? But there's penalties now associated with it. But I'm telling you, it is the easiest thing in the world is typically, my clients don't maintain the ledger, their management company does. Call up the manager, hey, this person made this request, email them a ledger. Problem solved. Okay, rules and requirements to provide copies for rules and covenants. So under the Association or HOA Act, on July 1st of 2024, a statute came into effect that said by October, you have to mail everyone a copy of the current rules and regulations. I could not tell you why. I mean, everybody gets a copy at closing generally anyways, or gets it email or can go to the association's website, but you had to send notice to them. So if you have not done so, if it's on your website, send every owner an email with a link and say it's on our website here. If you do not have a website, which is rare these days, you need to send a copy of the current rules to the association or to the homeowners. Condo associations can have a directory. It's optional. Unit owners have to have the ability to opt out or opt out of providing certain information. And if an owner provides information and it's incorrect, the association is not responsible for that. Let's talk about association websites. Does every association here have a website? Yes? No? Highly, highly encourage you to work with your management company to get one up and operational, even for the 16-unit condo, because it is so easy. If you have your manager keep it relatively up to date with a copy of the governing documents, the budget, the financial report, copy the meeting minutes, right? And all you do is you go to the manager and say, hey, put that on the website, right? Look, and they just smile and that's it, right? I highly, highly encourage it, because when homeowners come to you and say, we don't have this information, we want to do a records request, it is so much easier to say, we'll just go to the website, right? And that's not necessarily a publicly available website where anybody in the world can view it. Generally, you got to log in as a member. You're given a password, you're given a username, you log in and you can see all your violations, all of the budgets, all of the meeting minutes, but it allows you to keep your membership informed. I think whatever cost is associated with doing that is well worth it, because as a volunteer board member, you don't have all day to deal with fulfilling homeowner complaints and searching for records. Just put it on the website. As of January 1st of 2026, every condominium with 25 units or more, so you said, I think it's 16, right? So you're exempt still, but I would encourage you to look into it. Will have to have a website. And as of January 1st of this year, every HOA with 100 parcels or more must have a member accessible website.
Now, is this a website that Vesta keeps for us, for instance?
I don't want to speak for them. Do you guys offer that as a service? Yeah. I have some clients that have like a separate website domain operator. I think it's very natural to have your management company at least have access, if not host that website, simply because you're putting the official records up there. And so they're the ones that are the custodians of it. So it's very easy because the management's putting together the minutes, right? They're, keeping those minutes in our minute book. Is when they get back, they just put that on their website. If I have management in a domain operator here, it becomes a little difficult. So
I just shut down.
Yeah. So it's in what if the website domain operator is not performing and all that stuff. So it's very natural to have it associated with the management company. And I know you guys do a good job of maintaining all that. So what has to be on your website for HOAs? Copy of the governing documents, rules, executory contract, a list of your contracts. You do not actually have to put your contracts online. You just have to put a list of what they are. List of bids for the HOA, the annual budget, the financial report, so that'd be the year-end financial report, contracts involving conflicts of interest, notices of board meetings, notices of unit owner meetings, copy of your insurance policies, inspection reports, the SIRS, the Structural Integrity Reserve Study, the milestone inspection report for my condominiums of 3 stories or more, and in condominiums, copies of your building permits. Again, you can see that once you undertake the task of getting this all online, right, it's just updating it. But for every homeowner that sends in a request, you can just go ahead and send them a link and they can access it. Okay, we're going to talk about year-end financial reporting. Was there any other questions about website or access to official records? Hearing none? No? Okay. We talked about budgets, which is a forecast of what is forthcoming for the upcoming year. This is a review of what occurred. Okay? Important, because you have to understand where you're going, and then once you get there, you have to understand what occurred to go ahead and get there. And so at the end of every year, an association is going to go through some sort of financial reporting. We'll talk about what the differences are. So we're going to talk about financial reporting requirements, types, and who prepares them. So it provides a summary of the financial activities and financial position of the association. Typically, the purpose, it would be, an example would be a balance sheet, right? Showing the assets and liabilities, the expenditures over the year, the income over the year. It has to cover the association's fiscal year, which is generally January to December, but there are some differences. And you just follow what your fiscal year is. So if you look on your budget, You see what that budget year's for, right? We talked about it has to say from what date to what date. Your year-end report will always match that. Okay, so one thing it's going to disclose is what your revenues actually were. We talked about your budget indicates what you expect them to be. It will indicate what they were as the end of your fiscal year, right? And you can see those are basically the same categories as what was on the budget. And it will tell you what are the actual expenses of the association for that year. Turns out that if you take what your income was and what your expenses were, you can find out if you ran an operating surplus or an operating deficit. When you have to do it. So you have 90 days after the end of your fiscal year. So generally that would be like March 31st, around then, to enter into a contract with either your bookkeeper or your CPA to undertake the work, if you're going to use them. And you have 120 days for delivery. In an HOA, you have to provide a copy or written notice that a copy is available upon request. We go back a few slides, you can see on the website, it has to be put on the website. So generally what you do is when the audit comes in or the reviewed financial statements come in, you are at that point in time sending notice to everyone, this has been completed, it's uploaded to the website, please check that. Okay, so there are several levels that we're going to talk about as far as the intensity of the financial report. The lowest level is a report of cash receipts and disbursements. This is a general ledger, right? It just starts in January and goes through December and shows all the money that came in and all the money that went out. It is the most basic form of financial report. Only associations with less than $150,000 in income are allowed to go ahead and do this. The next step up is a financial statement, and it's a compiled financial statement, which is typically done by a bookkeeper, but not a licensed CPA. It provides no assurances as to the accuracy of the information. They're just taking the data provided to them and putting it in a more organized and cleaner format. There is a reviewed financial statement, which is generally done by a CPA. It provides limited adequate assurances as to the accuracy of the numbers. And then there is the full-fledged financial audit. And we'll talk about what the levels are for those. But that is where you have a CPA not only take the raw data, but test that data to say, okay, I'm going to go look at this. Do I end up with the correct formula? But also that auditor generally provides recommendations as to how to protect the association from financial abuse, right? So the auditor may come in and say, hey, under your current policy, the manager could just come in and just write a check for $100,000 and leave, right? Maybe we should have dual signatures, or maybe we should have a process by which somebody approves the check and then an email goes from your bank to 2 different board members and each one has to sign off on it, right? What thresholds exist in addition to testing, in addition to verifying the accuracy of the information. So this is the statement of cash receipts and disbursements. It's a cash basis, right? And it needs to include certain disclosures regarding reserves, special assessments, and so forth. The financial statement, right, we talked about. The difference here is accrual basis. I'm going to leave it to the treasurers to explain to you and your auditor to explain to you accrual and cash basis. But in a general sense, the accrual basis is generally what we look at when we talk about the GAAP standards for CPAs. And the required components are not only the report, but you get a balance sheet of assets and liabilities, statement of revenue and expenses, statement of changes in fund balances, sometimes cash flow statements. You got to pay extra for that one, at least what I've seen from clients. You get notes on the financial statements, right? About the testing methodology, about the reserves, and you get reserve disclosures. So a compiled financial statement, I kind of ruined these slides when I was talking about it, but that is where you are essentially creating a more organized version of your cash flow, your cash and receipts and disbursements. Between 150 and 300K is where you can do a compiled statement. That's as far as income. There are no assurances associated with this. Typically, it's done by a bookkeeper. It is one of the cheapest options right? But you don't get the assurances and the accuracy of the numbers by virtue of that. It's simply raw data in an organized form. Reviewed financial statements are associations with revenue of 500 or 300 to 500K. It's accrual basis. It's performed by a CPA. And you do get some analytical analysis and testing. And the audited financial statements, you're over $500,000 in income, or you're an HOA of 1,000 parcels or more, you have to do an audited financial statement. Generally, thousands and thousands of dollars, but it is the highest level of financial assurances when you look at the financial statements. And you get all of these benefits of it. I highly, highly suggest that when an association is looking at an auditor or a CPA, to go through and say, which one should we do? Now, obviously, if you're over $500,000, you don't have a choice, right? Unless membership says you can. But there are clients that strategically say, look, our revenue is $175,000 per year. All we're required to do is a reviewed financial statement every year, right? However, every few years, we're going to get a full-blown audit done, just to make sure that there are no abusive practices going on and we know where all the money is. You can always go higher. You cannot go lower without membership approval. Year-end reserve disclosures. So you need to have beginning balance, assessments, ending balance, amount to fully fund reserves, and there's some additional disclosures there. And we talked about the board's decision if it wants a higher level of voting. If you want to do a lower level of voting, it requires membership input. Importantly, you can't vote for a lower level every year, right? So if we do it for year-end 2024, for year-end 2025, we have to comply with whatever the statute requires us to get. The reason is we want to ensure that at least every other year, we're meeting the minimum statutory requirements. If you vote to utilize a lower reporting threshold, it's only good for that year too. So if we approve it for 2024 to do a reviewed financial statement instead of an audit, we can save some money. We will not get the accuracy of the data, but we must obtain the membership vote to do so. For HOAs, there is the ability of the membership to petition the board to force a higher level. So you could force your board to do an audit. If you receive a petition by 20% of the membership, you have to hold a meeting, and a majority of the total voting interest is required. If approved, you're gonna have to amend your budget because the reviewed financial statement could have been X dollars and an audit is going to be Y dollars. And a lower level of reporting, it's a majority of the voting interest at a present at a meeting which a quorum is established. So, for example, in an HOA, if we want to go from audit to something lower, we hold the meeting, it's a membership meeting, we send out limited proxies, we have ballots there. You have to establish a quorum, which is generally 30%. It's a majority of those people present in person by proxy. It's not a majority of the totality of the membership. Okay. This is slide 71 is a good summary and a summary of when you have to use the CPA. All right, any other questions about reviewed financial statements? Probably the most mundane topic on today's presentation, but very, very important in developing the future year's budget. Very, very important of understanding where your money is in the financial position of the association. Questions, concerns? Hearing none. All right, so we're going to talk about milestone inspections and structural integrity reserve studies. I have one person here present this applies to. So I'm going to kind of go through it kind of quickly, but feel free to tell me to slow down. I'm sure there's people online that want me to explain everything. Right, so you've experienced it firsthand, so you could probably give this experience, right? If you ever think about buying in a condominium, 3 stories or more in the state of Florida, understand that this will give you some input as to what to look for when you're buying. In the wake of the Champlain Towers collapse, Senate Bill 4D was passed. It requires 2 things now of condominiums of 3 stories or higher. One is a milestone inspection report. We refer to that as a MERS, M-I-R-S, right? That is a snapshot in time. Here's the condition of the building. The goal was that when that milestone inspection report was done, to understand, are there problems with the building that need to be addressed today, right? And then once you do it, every 10 years thereafter, you're required to do it. The goal is never to have the loss of life of what occurred at Champlain Towers. So you take the snapshot in time done by an engineer or an architect or a design professional. The other component of that is a structural integrity reserve study. Does everybody know what a reserve study is or have experienced a reserve study? Yes, it's brutal, but it gives a real clear picture of here are the identifiable deferred maintenance items and capital expenditures. Here's how much money we have today. Here's when those are going to fail. Here's how much money you have to have on hand at that point in time. And essentially, it's a forecast that tells the board how much money it should put away each year into the reserve schedule, right? I highly recommend that clients utilize that as a service. I know it's not cheap, but boy, is it easy when members challenge you on stuff to say, we hired this professional from the Community Association Institute, right? Or the Association of Reserve Specialists. Came out, they gave us this reserve report. It was a few $1,000s, but now we know our categories. Now we know our lifespan. Now we know our replacement costs. We have a full picture of the next 20 years of this association in what we have to look at. Every few years, 5, 7 years, you should go and get that redone. So it gets updated with current prices. They'll take a look at the water tower. Is it worse than, or is it better? The roofs, elevator, items like that.
What you think?
It really, really makes you think. And I think it's hard for associations to have a full picture in developing the reserve schedule until they bring in professionals such as that. Because absent that, what you're doing is you're calling a vendor, a roofer, who wants the job today, right? Or wants the money in 2 years, and you're relying on their information. Certainly, they're probably going to do a good job, but they're not independent. A reserve specialist job is to come in and give you a picture today of what exists and when it's going to fail. That's how they make their money. Their job is to provide accuracy as that. Their job is not to solicit more business from you down the road as far as that infrastructure item. So I say that because that's what plays into a structural integrity reserve study. It's more particular as to high-rise condos, but in a general sense, I think every association, if the budget allows, should be looking into that. So milestone deadlines, if the building is turning 30 years of age, right, or is 30 years of age, you have till the 31st of that year. So if the building was built in 2000, right, you have till 2030, December 31st of that year. For buildings built on or before July 1st of 2022, you need to get it done now. And for buildings that are older than that, hold on, let me just move this here. Let me go back here. 30 years old on or after July 1st of 2022, you actually have till 2025 to go ahead and do it. So the association, and it's a little confusing for clients that are running into this, it's not under Chapter 718. It's under Chapter 553-889, which pertains to the Florida Building Code and what the requirements are. What you're required to go ahead and do is perform the milestone inspection that's done by an engineer, a licensed architect, or a design professional. After you receive the report, within 14 days, you must notify all unit owners that the inspection has been completed. And within 45 days, the association must distribute a copy of the report to all members. Now, that report, there's a phase 1 and a phase 2. A phase 1 is a visual inspection, and I actually went to a couple of these, right? Interestingly enough, a golf club, it was I think a 4-iron, right? And I have an engineer going around on the balconies tapping them, but it's an audible, right? They can tell if there's cavities under the concrete, right? You can also bring in ground penetrating radar to go to look at these things. They take drones up, especially for the high rises. But what they're looking for is signs of exterior failure on the building. If they find one, then you are required to engage for that component in a phase 2, which is We're actually going to dig in and figure out what's wrong here and repair it at that point in time. Most clients were very, very hopeful, and I think most clients here are very lucky that they had good engineers. They were able to come in, and for the most part, it's a limited phase 2, if a phase 2 at all. Most clients were able, because they've been keeping their properties up, to get through a phase 1 and get that check mark. Okay, it does not mean you get 10 years of no maintenance, just so everyone knows, right? It means that you passed inspection this year, we're going to do it again in 10 years. In the meantime, if we start observing exterior deterioration, take care of it, right? Especially in high-rise condominiums with balconies and all those components, because once that rebar starts to spall and water gets in there, doing it when that first occurs versus a year from now is triple the price, right? Because it just goes back and back and back, and all of a sudden you're in the person's dining room, right? Replacing rebar at that point in time. All right. So we talked about it's an architect or engineer, and we talked about the phase 1 in the visual inspection. A phase 1 must be completed within 180 days after the owners of the building receive a written notice from the inspector. So the thought process was everybody had till essentially, if your building was older than 30 years, December 31st of 2024 to turn in your report to the building department. However, this contemplates that if you're less than 30 years, if the building department writes you and says you need to commence an inspection, we want an inspection, you have 180 days to take care of that. If there are no signs of substantial structural deterioration, and that's the terminology used, and I'll defer to the engineers on what that means, no phase 2 is required, and completion of the phase 1 must be submitted to your local building department, and they will keep track of all of this information. For those clients 30 years and older, you were required, or are required, because we still have 12, 13 days, right, to get this process completed and get that submitted to the building department. I'm very hopeful that most of you have already completed that process. A phase 2. So let's assume the engineer goes in there and says, you know, on the balconies on the eastern side of the building, we're seeing substantial structural deterioration. That will be in the phase 1 report. That puts you on the clock to undertake a phase 2. A phase 2 by statute is simply destructive testing to determine what's wrong. And then you need to commence repairs. Practically, what's resulted is you to do destructive testing on your balcony and then submit it to the building department and say, we'll fix it in 6 months. So phase 2 is practically resulted in the engineer going in and saying, because we're cutting out this balcony, we're going to do the concrete restoration today, right? Or we're going to replace the balcony railing today. We're going to replace the exterior spalling concrete today, the window today, as part of that process. At the completion of the phase 1 or 2, you have to give a sealed copy of the inspection report with a summary of the findings to any owner, which is not subject to the condominium form of ownership. So in those residential condominiums that live in a mixed use, sometimes you'll have condominium units above commercial, right? This would be a requirement that you provided to those non-condominium unit owners. And it is part of the association's official records. Okay, so this is slide number 79. Really good summary of what is required as far as the milestone inspection report, or the MERS. It is only applicable, and I think I mentioned this, to residential condominiums of 3 stories or more. Okay, structural integrity reserve study. So this is the second component of Senate Bill 4D. Residential condominiums, 3 stories or more, must be completed every 10 years. This is essentially a more in-depth association reserve study based on specific statutory criteria. It can be performed by any qualified person, and it's based on a visual inspection. Because this came due at the same time that everybody's milestone inspection report was due for buildings 30 years or more, generally you've either had the engineer working hand in hand with a reserve specialist, or the engineer utilizing one of their bookkeepers or referral sources to prepare the CERS in conjunction with the MERS, but prospectively they do not have to be combined. It needs to be done by certified reserve specialists or professional reserve analysts or by an engineer architect. I know a lot of really good engineers and architects. I don't know if I would have them do a spreadsheet though on this. I would recommend you go to a reserve specialist. They need to be certified by the Community Association Institute, or I think is the APRA, which is the what is it? The Association of Reserve Specialists, Professional Reserve Specialists. But another trade organization, right, that specifically is dedicated to doing this type of work. The goal is to have a very robust, thorough reserve study that gives the financial forecast under this over the next 10 years as to those infrastructure items. You need to identify each item, state the remaining estimated useful life, and the maintenance costs to go ahead and replace it, and then that creates a reserve schedule. As you can see, other than the additional categories required, right, it is very much the same process as you would calculate any reserve schedule. Within 45 days after receiving the SIRS, you must distribute a copy to each unit owner. Within 45 days, you have to tell the DBPR you're a good boy or good girl, and you took care of this process. And the DBPR is going to create a database of who has completed this and who has not. An association may complete the structural take reserve study in conjunction with or simultaneously as the milestone inspection report. The SIRS must be completed no later than December 31st of 2026. However, it doesn't have to be completed till then, but on your 2026 budget, you're required to reserve for those 11 categories. So in practical sense, you should have it in place at least starting this year. The association may satisfy it with a previous milestone, meaning that the data from the milestone inspection report will go into that. The inspection or inspection performed has to be within the past 5 years. So if you've done a reserve study within the past 5 years, you can use that data. And it's based on a visual inspection. All right, any questions about SIRS or MERS? Sure. No, hearing none. No questions from the one member in the audience. All right, condominium elections. So we are going to talk about elections, not only of condominiums, but HOAs, but two distinct and separate beasts. What I want you to know is if you live in a condo, the great news, especially for the managements and legal counsel, is it's all uniform. Doesn't matter what your documents say, the statute controls, okay? In an HOA, it's document specific. The good news is most documents are somewhat similar as to the process, but when a HOA client calls me, I say, let's pull up your bylaws and go through it. When a condominium client calls me, I say, let's follow the statute. So you need to know that. So let's talk about the election timeline, candidate eligibility, ballots, conducting the election, and board member certification. Starting with the last one real quick, we're getting towards the end. What are we at? 89. We only have 110. And the last 5 are pretty quick. So again, 4 hours of material. I'm going to stick around for questions, but the good news is we're going to get our certification. Okay, so let's talk about the election timeline. 60, 40, 35, 14. Those are the dates for the condo. There'll be a slide on it, but I'd just like to talk about it in a general sense, right? That election timeline is uniform throughout the state of Florida for every condominium. In an HOA, it's driven by your governing documents. If your governing documents don't address it or don't require it, guess what you can do? You can follow that timeline. I think that is a very orderly timeline, right? It ensures that mailings go out with time for people to turn in their ballots, to understand who's running for the board. So if your HOA documents dictate a timeline, you got to follow that. But if they don't dictate a timeline, I highly encourage you to do the first notice, second notice, and meeting process. Okay. So HOA elections must be conducted in accordance with the bylaws. In HOA elections, unlike condominiums, you can nominate yourself from the floor of the meeting unless your governing documents provide an advance nomination procedure. It's a lot of legalese. I'm going to break it down for you. If your governing documents say, if you want to run for the board in an HOA, you got to let us know by 40 days before the election, which is what the condo statute requires, right? You have advance nominations. If your bylaws say that if you want to run for the board, you have to let the board know by the third week of December for the January annual meeting, you have an advance nominating procedure. If your governing documents do not state a deadline by which a candidate has to say, I want to run, by default, you have to allow nominations from the floor. Meaning you show up to the meeting, you may have 3 people you know are going to run, right? Because they said they wanted to run, but you could have John Carrigan show up and say, I would like to run too, right? And you have to have an election if we only have 3 open seats, right? So when you look at amendments to HOA governing documents, one feature I love to put in the bylaws is an advance nomination procedure, because it's hard enough to get people to run for the board. I don't want to have to prepare for a whole election, not knowing whether one's going to exist because somebody could show up that night and raise their hand, right? So I like to put in something very similar that says, look, if you want to run for the board in my HOA, we're going to send you a first notice. 40 days before is the cutoff. If we get to day 40 and I have 3 open positions and three people that turn in their intents to run, there's no election that year, right? We're just moving on, right? We're gonna have the annual meeting, we're gonna get together, right? Somebody's gonna bring cookies, right? But we know we're not gonna have to worry about an election and do an election mailing. If you don't have that language, you're not gonna know till the night of. So something to look at. Understand that if there is a dispute over, you should have allowed nominations from the floor as to member eligibility, as to something that appears improper about the election in the HOA, it is subject to DVPR jurisdiction. Okay. This slide 90 is a great slide to keep in mind. This is for condominiums. And if you're an HOA who follows my advice and adopts a condominium-like type of election process, this is a great slide for you. So 90 days before my election, I am going to suspend anybody, right, that is more than 90 days delinquent in a monetary obligation to the association. You're not going to pay like every other neighbor in our community. I don't want you voting, right? So the board needs to take that process 90 days before. 60 days before, we are sending out the first notice of annual election. Hey, everyone, we got an election in February, right? If you want to run for the board, please let us know by this deadline. That's like the first notice that goes out, okay? 40 days before is the cutoff if you want to run to the board. So with that first notice, it's the notice, hey, we're going to have a meeting in the election. Yet attached to that is a notice of intent to be a candidate for the board of directors. The DVPR form, but you can make up your own form. But you have to tell people, turn in this form if you want to run, right? At day 40 in a condominium, in day 40 in an HOA that has the governing documents, I know whether there's going to be an election or not because I know how many people are running for the board. At day 35 in a condo, you have to turn in your candidate information sheet, right? Which is that piece of paper that says, I should be elected because I was a business person. I served on prior boards. I have a CPA back, whatever it is, your sales pitch to the membership. That is going to be included in the second mailing, okay? The association is not to review the accuracy of the statements. The association is not to make any changes to that, right? In fact, I recommend that we really don't look that hard at it, right? Because sometimes there's some pretty nasty stuff in there, especially when they're going after other candidates. But the point being is they turn it in. We don't judge the substance of it. It gets put in with the election mailing. Between 34 days and 14 days is when our second notice goes out. That includes notice of second meeting. That includes my agenda for the annual meeting. That includes my mailing for the election ballots, right? In the double envelope, which we'll talk about in a second. That includes any other information you feel people need to have ahead of the meeting. Limited proxy, for example. If amendments are up, they will go in that mailing. You can mail it as little as 14 days before the meeting. I highly, highly recommend you try to get more time, right? Because the more time you give, the more opportunity you give for people to respond, right? And submit their information or submit their ballots as it pertains to it. Especially, we have a lot of clients that live in Canada. And for some reason, there's a somewhat of a delay for mail to get from Florida to Quebec, right? Wherever it may be, right? I don't mean to pick on Quebec, but just like in general, you have people that live in a different country. It's going to take time. If I mail that 14 days before, there's very little chance they're going to receive it. They're going to be able to be informed, and they're going to be able to return it. We're going to get it before the meeting. So I highly encourage management cannot mail it out before day 34, and they're only going to get the candidate information sheet on day 35. So it's not going to be day 34, but if you get to be day 25, you've now afforded 10 extra days for people to give their vote in something. So I highly recommend that go ahead and be done. So we talked about the first notice, date, time, and location of the meeting. That's all the information that has to be in there, along with the the notice of intent to be a candidate. And that is this one. You need to put on there that you have to turn in by this deadline. Your first notice has to indicate that. So make sure you pull out the calendar. I like to check Google twice before I put the dates in there, just so I have everything lined up. And they have to submit the notice of intent to run. They could physically turn it in. They can mail it, right? They could email it. If you mail it and they mail it 41 days before and you don't get it to day 39, you did not receive it in time. They're not eligible to run for the board, right? Email is probably the best way because then you have proof of delivery at that moment. Who's not eligible? So turns out that if you go out and commit felonies, Florida legislature says you shouldn't be on the board of directors. You've been convicted without full restoration of rights. If you've been suspended or removed by the DDPR, so if you've embezzled money from your former condo and moved to a new condo, you can't run for the board. Okay? Pretty simple. In an HOA, if you're delinquent in any monetary obligation owed to the association, if I go request a new key fob and it's $25 and I don't pay that $25 and that's sitting on my account, I'm not eligible to run for the board. So if you intend to run for the board, call up your manager, right? Or call up the board. Hey, do I owe anything? Make sure you're current, right? It's whether you're current on the last day you're eligible to nominate yourself to be a director. So if I have an advanced nomination procedure, whatever that date is, if it's 40 days, if it's 30 days, whatever it is. If it's at the meeting, I've literally had to be at an annual meeting and we have the AR list, always bring it managers to the meeting, right? And if the person raises their hand and says, I would like to run, we look, does it say 000? We're good, right? And if they don't, I have to have that awkward conversation in the membership meeting. Hey, can you get out a checkbook, right? And write us a check for $47 for this key fob. So you just need to make sure if you're going to run for the board that you don't step in that pitfall. For condos, it's when you submit the intent to run, that 40-day deadline. The candidate information sheet, it's 8.5 by 11. Yep, background, education, qualifications, and other relevant information. It's distributed with that second notice of mailing with the election material. You're not allowed to edit, alter, or modify. Every year, I get the call where somebody uses their candidate information sheet to, in the person that's calling me, they're defaming me, okay? The association's obligation is to mail it out as is. You cannot alter or modify that candidate information sheet. You are then taking authorship of it, and it's specifically prohibited by statute. So whatever they send in, that's what gets mailed out. And it becomes part of the association's official record. So if somebody's going to be that person, it's always going to be part of the official records, and every member is going to see that they're that person. Okay. The second notice, this is for condos only. HOAs, it's open elections unless your governing documents require a closed ballot election. In condominiums, it's always secret ballot, a double envelope, or closed ballot election. There's an outer envelope, there's an inner envelope, there's a candidate information sheets, and there's the notices of mailing. That's the package that gets mailed. As a homeowner, what do? I go ahead and fill out my ballot. I don't sign it. I don't include any other markings of who I want to be my board members. I trifold it, I put it in the inner envelope, and I seal it. I don't make any markings on any of the inner envelope, right? I take that inner envelope, I put it in the outer envelope, I seal it, then I sign the outer envelope, and that is what I submit. The reason that ensures secrecy of ballot is because when we receive it, we put it in the bin, the lockbox, right? And then at the meeting, We will open the outer envelopes. We'll verify that, yep, that's them. Check them that they've submitted a ballot. Open the outer envelope. Take the inner envelope out. Put it in another bin, right? And only after we've opened all the outer envelopes do we even look at this bin over here. We shuffle that bin, right? It's the last person. We don't want to know who they voted for. And then we take that bin, which has no markings on any envelope, and that's when we start to open them. And we pull out the inner envelope, right? And that's when we start tallying the votes. But that's how you create the secrecy of the ballot. That's why it's so important to have very clear instructions to your homeowner about the process by which it's done. Now that I think about it, we should create a YouTube video of how to do that. So you can write homeowners, or Vesta should do this. That's a great idea, right? Yeah, they will. But it is, I mean, I've received it, and I can see why somebody that doesn't live and breathe this is like, why do I have to do all this, right? Well, it's to maintain secrecy. Because the DVPR has said this is why it's confusing. But you need to have clear instructions to your members. The people that are opening these outer envelopes at the meeting need to have very clear instructions, right? So that there is no identifiable way to take that outer envelope signed by the owner and match it with a ballot on the inner envelope.
What about the proxy? Can you do that envelope, not the secret ballot?
Yes. Yep. So when you take out, a lot of times what the association will do is they'll either include a proxy envelope to send back separately, or they'll say put your proxy in the outer envelope, or they'll put the proxy language on the outer envelope. So the outer envelope essentially becomes your proxy. There's multiple ways to go about it that I can talk to you about, but yes, if we open the outer envelope and there is inside a unmarked inner envelope that's sealed and a limited proxy, I take out the limited proxy, I put it over here. I take the unmarked inner envelope, I put it over there, right? And I always have to keep the election material. I put the outer envelope here. Yep, so I have 3 piles at that point in time. Okay. Notice recap. 95. Another good description of the notices that are required. Again, I would highly encourage HOAs, which are document driven, to take a look at the condo statute, because it is very formal in the requirements that have been done. It's been tested time and time again through arbitration provisions, and therefore provides a lot of guidance that when hiccups do arise, because every election they do arise, there's actual guidance on it, and we're not shooting from the hip and answering, here's how you handle the situation. Okay, when you send out the ballots in the inner envelope, they have to be uniform in color and appearance. The names of the board members have to be alphabetical by surname. I literally had to tell clients, I'm sorry about your election results, but you have to undo all of it. We have to redo the election because we didn't put them in alphabetical order. So these are simple things that can be missed. You can't indicate who's an incumbent, right? Of course, on your candidate information sheet, you could say, it's been a pleasure serving this community for 15 years. You can always indicate that, but not on the ballot. You can't put a space for signature lines because people will sign it, right? We don't want that. And you can't have a unit identification. So the ballot is literally just a ballot. Association name, candidates in alphabetical order by surname with boxes. That's it. Now, the future, electronic voting. I highly, highly encourage clients to look at this and the feasibility of it. There's advantages and disadvantages. The advantages are, 1, your amount of participation in your meetings will skyrocket. I have never had a client that implemented electronic voting that said, yeah, we have less people vote. It's always going to be more, because you can do it on your phone, you can do it on your computer. You've just made it that much easier for people to cast a ballot. So you will get a higher participation rate. The other advantage is that you will know the total count going into the meeting, right? Where the vote is, whether it's an amendment vote, whether it's an election vote, right? Because you're going to get an email from the vendor that says, here's how many people voted, right? Here's the vote results as of now. Now, you don't go out to the meeting and say, before you turn in your ballots, anybody that's old school, here's where we are. You don't do that, right? I generally recommend that the manager get the results from the vendor, seal them in an envelope, and that manager holds on to that until the vote is completed. But the manager will have that information. If I have a 100-unit condo or a 200-unit condo and 50% of those people voted, right, electronically, and I have that data as I go into the annual meeting, one, I know I have quorum, right? So I don't have to worry about that. And number two, when I'm checking people in counting ballots, I'm only having to count half the ballots, right? Because people have already done it electronically. So your meetings are going to become much, much more efficient in that regard. Disadvantages of electronic voting. Number one, cost. It's generally a per door fee. Is that what management's been seeing?
Yeah.
Like it's a per unit or per door fee, right? And if you do multiple meetings per year, then it gets added on to that. So there is a cost associated with it. You have to use a third-party vendor, right, to go ahead and do this. Does Vesta doesn't have anything internal, right? Yeah. A lot of the management companies have said we don't want to be involved in being accused of data stuff, so which is wise. So there's going to be a cost associated with it. The other disadvantage is you cannot force people into electronic voting. It is an opt-in system under the statute, meaning that I have to, if I implemented it today, I have to send every member a consent form and you have to opt in. As you know, with any association, you never get 100% people buying into anything. So as of today, you're always going to have a hybrid system where you're going to use the vendor, you're going to pay for every unit in your condominium, and only a component of those members are going to utilize the service. So I have some clients say, well, we're only 50% of the people are signed up, so we're wasting money. I can see that argument, right? But you just have to weigh, is it worth it from the perspective of organization and expeditious meetings? Is it worth it from the perspective of member participation? I think it's a great feature. It prevents, I don't know how many meetings I've been to where somebody says there's a miscount, right? Well, we just have the data from the computer, right? And that's the vendor's going to provide a reliable number to us versus people that have come and, maybe, John forgot his glasses. And so we're doing the tabs, but maybe it's not so accurate. So I think the advantages outweigh the disadvantages, but you're always going to have a hybrid. You're always still going to have to do the old school method for those people that haven't opted in. If you do implement electronic voting, it requires a board meeting, 14 days notice to the membership of the resolution to implement it, and you have to work with legal counsel. Please work with your attorney to adopt the resolution that comports with your bylaws so that the process online comports with what your bylaws require. These vendors, they do a decent job, but I've seen too many vendors say, here's our template, go adopt this at a board meeting, and that does not comport at all with what the requirements are under your bylaws. And now the whole election is subject to challenge, or the amendment is subject to challenge. So please have your legal counsel do that. And we have the forms. It's more about tweaking our forms to meet your individualistic needs, but it's something important that's been done. The board, once you authorize online voting, you have to offer it to members. So once we've opted into the system, right, the board would have to rescind the resolution if it decides it doesn't want to allow it. So if we start it for 2025 election, it's going to continue into perpetuity unless we rescind that resolution. And the board cannot opt to say, well, we're going to do the old school method for this particular vote. You have to offer it to membership. All right, conducting an election. So this is in a condominium only. HOA people, cover your eyes. You need to have 20% of your total membership cast a ballot. Some of you may say, well, but my condo quorum is 50%. An election is a separate, distinct, but consecutively or simultaneously held event along with your annual meeting. To proceed with the annual meeting, take votes on contracts, cable contracts, to take votes on amendments, conduct association business, adopt prior meeting minutes, you have to establish a quorum, which in condominium by statute is 50% plus one, right? But let's say we don't get that. If I still get 20% of the membership to cast ballots in person or return the ballot in the mail, I can still have an election without an annual meeting, right? The reason is they want to get these new boards and the new blood in there. So that's why they lowered the threshold of that. In an HOA, so condo people, cover your eyes. In an HOA, you have to establish a quorum to conduct an election. So in a condo, it's 20%, regardless of whether you establish a quorum. In an HOA, you have to establish a quorum to conduct an election. Okay. Now, yeah, and a quorum, correct, a quorum of the membership, and by statute, in an HOA, quorum is 30% or a lower number if provided in your bylaws. Now, a little sales pitch for the DBPR is you can send in an email to ombudsman@myfloridalicense.com and request that they send down officials to oversee your election. I have found this to be extremely useful when you have a hotly contested election, right? There's varying packs of people and groups that are all fighting for this position of power. You got to pay their fee. I don't know what their fee is. You can certainly negotiate that with them. You got to give them plenty of notice. You can't email them 2 days before, right? But to bring in the state and essentially say, look, we're going to, I mean, you're still going to tally the votes, but they're going to sit there and help you through the process. Essentially, your election is going to be unchallengeable, right? Because you've had the state come in and oversee everything. Well, who do you go to complain if you think it was done wrong? The state, right? So it's just a question of whether you want to spend the money, whether they have availability, right? And look, you know, if it's a standard election, you're just trying to get people on the board, right? Probably not worth it. But we all have been in those scenarios where you live in a community where there's a hot topic, it's very adversarial, and no matter what, somebody's going to challenge the election, right? Meaning you're going to pay your attorney to defend the position of the board in making certain decisions. I would just say, hey, let's email them, have them come out. And I would still have the attorney at the meeting. You're still going to have the membership and the chair conduct the meeting, but you're going to have the oversight of the ombudsman to walk through the process. And essentially, if there's a question that arises, we just turn to them and say, what is this? What's the state's position on this, right? So it's a great program that exists. There are not enough people at their office to cover every association in Florida. So if you have one coming up and you think that they would be necessary, I would reach out as quickly as you can. When a board member is ousted, right, you have an obligation to release all official records of the association to the incoming board within 5 days. The good news is if you're using management, it's not really a big issue. Maybe the president took some files home, maybe the treasurer, which is pretty typical, the treasurer at least has duplicates. But you have 5 days to turn that information in. If you don't, the DBPR will come out, right? So you have an obligation to do that, no matter how much you dislike the people that are now in power. The failure to comply can subject you to civil penalty. So the DBPR doesn't find the association, they find John Carrigan, right? Because I did not hand over the official records in my possession. And if I decide to burn them, because I'm sad that I lost the election, I can then go to jail. So again, nothing any of you would do, but there are these consequences because occasionally these bad actors do exist in our state. Okay, if there's a challenge to an election, so proper notice wasn't provided, names were not in alphabetical order, the association improperly counted the ballots, right, or disqualified some ballots, whatever the grievance is, there's a 60-day clock in which to go ahead and challenge it. You have to file a petition for arbitration with the DBPR saying this was done wrong. I say this as you as board members, if we get to day 61, we don't have to worry about it, right? So sometimes it's about waiting out the clock. A lot of times the challenges don't hold water, but the person does it because they have some other agenda, and the goal is to get us past the 60-day deadline. Okay, let's talk about board member certification. So I open this by saying, why are you here, right? These are the slides. I think it's the next 3 or 4 slides. But what you're going to get, you're going to get the certificate, right? That I go ahead and sign, and it's going to have your name on it. You're going to go give that to management. If you don't have management, you're going to give that to the secretary of the association. And they are going to put that in the official records. And if anybody ever challenges you, right, you'll have that certificate to say, no, I've been properly trained and certified under Florida law. We talked about the fact that if you are an existing condo board member, you have till next June 30th to go and complete it. But the good news is anybody here today online or in person, you are going to be certified at the end of today. For HOA board members and for condo, Remember that in addition to this new board member certification course, you have a CLE requirement. When we get done with today, I'm going to give you my assistant's email address. If there are topics, not particular to your community, right? But if there are topics that you want to hear about, right? Feel free to send my assistant an email, and we will, if we get enough response on that topic, provide a 1 hour or 2 hour CLE on that. I've gotten a lot of requests historically. We're talking about emotional support animals and how the law applies to that, about enforcement techniques, about collection techniques, right? That we look at and what considerations go into that. So we are always looking to serve our clients, right? And make you better board members. And if I get 4 or 5 emails on a specific topic, that is an indication to me that this is an area where education is required, and we're happy to go and provide that to you. Not only to fulfill your requirements as a board member, but to make you better able to serve your community. Condo clients, 1 hour annually. HOA clients of 2,500 units or less, 4 hours, 2,500 or more, 8 hours. That's a lot of time. What's the manager requirement? Does anybody know? 15 hours. So basically at that point, you're halfway to becoming a manager. So, okay, there's some QR codes here, but this is a helpful information as it pertains to the 3 stories or more condominiums for MERS and SERS requirements. And if you log on, the DBPR, Division of Condominiums, has a website on the DBPR website. They have a lot of educational material, meaning that it's much, I think they have basically this presentation, but they have a lot of guidance. There's about an 80-page handbook on how to develop budgets and operating accounts and reserve accounts. Really, really informative. Their job is to be there to educate you all and make you the best board member you can go ahead and be. And they are always there to serve in that capacity. So I even sit there sometimes and a client asks that one question I haven't experienced, and sometimes I find myself on that website to go and look for it. Yeah. The CTMH is the Condominium Timeshare and Mobile Home Division, and this is just some additional information as it pertains to it. There is on the DBPR website not only the guidance, but there's something called declaratory statements for condominiums. And that is somebody writes the DBPR and asks a legal question, right, about an election or about what is a material alteration. And occasionally the DBPR, they issue a couple per year, will come out and provide guidance on that. It's not like a court decision, doesn't pull that precedent, but it's a great way that you can go in there and search by topic and see if something's been touched on by the DBPR. And certainly it's helpful from our perspective, and I think I've never been a judge, but like from a judge's perspective, to get the division's interpretation of a regulation for a portion of Chapter 718. Additional QR codes that you may want to go ahead and look at, and a phone number if there's any questions. And additional, they put a lot of QR codes in here, so hopefully they all work. And more QR codes. But I think that's it.